Well, hello there, everybody, my little friends here. Thank you so much for tuning in here today and being here with me and with our this very nice guest, distinguished guest, Attorney Yolie Medina. And I'm looking forward to talking about uh, a little bit about her background because I think most of us have seen her um, pop up on panel and discussing cases. And I'm also interested in what she is doing and what she's done in the past. So I want to talk to her a little bit about that. And if you have any questions, I think I asked in my community post if you guys had any questions to put them out there, but I didn't see any. So if during our conversation questions come up, please just post them here in chat, and I'll try to keep a look on that as well. And forgive me if I miss something in advance, because sometimes I like to get into discussions and I keep forgetting. I'm in charge of the chat. So excuse that. So without further ado, I'm going to bring up Yoli, and we'll have a little chat.
Hi there.
Hi, Yoli. How are you today?
I'm fine, thank you. How are you?
I am good. I'm good. Thank you very much. And thank you for being here. I really appreciate it. I've seen you around on panels, and we've been on panels together before
Together.
as well. And
Mhm.
I always enjoy talking to you. And so I'm very pleased that you showed up and you're here with us on my
Mhm.
little channel because I'm smaller than what you're used to.
Oh, no,
But
that's okay. I don't mind. I could talk. Yeah, no problem.
yeah. So basically, what I want to start doing is I want to start with, you. Uh, what's your background? Because we know you're an attorney, obviously, but I think you have an interesting background, and I would like to talk about that a little bit. And
Okay.
if you want to share what you can share with us, and
Hmm.
let's start there.
Okay. Well, I'll just tell you that, I have a bachelor's degree in psychology. I
Mm.
worked as a mental health worker for some years where I took care of severely mentally ill patients. And then I went to law school and I became an attorney.
Wow.
And for the, you know, for the maybe half of my career, all I did was sue public entities for the most part.
Hmm.
And I worked with the firm of Sayer and Chavez, and that was Federico Sayer and Cesar Chavez's son, Fernando Chavez.
Oh. Oh,
Yeah.
wow.
So I worked there, and they were into suing public entities. And so that's what I did for a long time. And I don't know if any of you know, but Federico Sayer had handled the Rodney King civil rights case. He handled it with Milton Grimes.
Wow.
And so there is where I got into handling cases that that were civil cases, but they resulted out of criminal
Like,
conduct or
yeah.
criminal cases.
Yeah. Yeah.
And I've had experience, like for example, with the UCI and UCLA Will Body Parts case,
Hmm.
where they were selling body parts
Oh,
and
yeah.
all of that, and it was a civil case against the University of UCI, and the Will Body director was selling body parts, and you would think that was a crime, but he was never charged.
Hmm.
But the civil case went forward, and we were able to get a class action settlement on behalf of some plaintiffs, and then settlements for each individual plaintiffs who really signed a contract with UCI to donate their bodies, or the family loved one signed a contract. And then they went a step beyond the director and said, well, you can have the cremains after we're done. And the cremains it was all wrong. I mean,
Hmm.
it was like you'd go, once they were acting as a mortuary at that point. So they
Wow.
were promising the cremains. And so what happened is, one of the plaintiffs went to scatter the ashes in the ocean. They had this big to do,
Hmm.
and in the on the outside it said so and so's name, and then when they went to scatter them, there was a tag which goes inside the remains, and it had the name of somebody else. So that's what,
Oh.
yeah. So it was,
What year
so
was this? I can't.
yeah, it
I
started.
remember hearing about it, but I can't
Yeah.
remember the
So
year.
it started in 1999 while I was in law school.
Hmm.
And then because it was such a complicated case, there was so many ins and outs, so many people, and so many other, there was a couple of other attorneys, like masses of people.
Mm-hmm.
So before I even became an attorney, it started. And then in 2002, as a newbie, that's when I graduated law school and I passed the bar. I was given that case.
Wow. So you
Why?
just went in the deep end.
I don't know why. Um, and I was working on it with Mr. Sayer.
Mm-hmm.
So I was like the grunt of the, and so it was in mid litigation. And so they were trying to split it off to class action versus individual cases. So there was a class action for those people whose families didn't get a promise of getting the remains back. But they heard about what happened. And it's really, so if you think corruption does not happen, it does. It happens right in front of your eyes. I mean, literally. And UCI Willed Body Program, the guy, this mortuary driver, testified in a deposition that he would pick up body parts like legs, arms, spines, I don't know, whatever, and pick them up in a plastic bag. Those big green plastic bags. And he would take a drive to he was called Harry's Mortuary Transport. And he would drive the parts to UCLA, and he would meet this, what he called a black doctor, on the third or 13th floor. I don't know. It's in an article somewhere. He would meet him on the elevator, and he would give them the bag of body parts, and he would get cash in return.
Ouch. Okay.
Okay. So this guy, Harry's Mortuary Transport guy, he, the driver was this big, huge Samoan guy. And when he got subpoenaed, which was my office, subpoenaed him for a deposition, he was angry. And I was like, oh my God. And so literally what happened is I got this testimony out of him. And for the first time, I don't know, maybe defense counsel said, we got to stop the deposition. I'm like, why? Because he testified to that, and they were like floored. They didn't know what to do. They were all in their cell, calling, and they didn't know what to do. And this guy was looking at me like, why did you subpoena me? And I'm like, oh God. So we had to stop the deposition.
Yeah.
And I swear I was paranoid after that. Very paranoid. And so what happened at the end of the day is we settled the cases, and there was a class action that settled, and so on and so forth. And, literally they were like transporting spines across state lines to Arizona. So it had to do with federal law. It had to do with the Uniform Anatomical Gift Act. And actually the work that we did on that case changed a part of the Uniform Anatomical Gift Act. And now when a body is donated, if body parts are taken apart, they have a barcode.
Okay.
And so it's tracked a whole lot better. Although that doesn't stop it. I mean, I know from Andrew Myers, there was something at Harvard University just recently.
Yeah, I read about that too.
Yeah. And so anyway, so it helped in California, but still the Uniform Anatomical Gift Act is what covers it, and it's a federal thing. And so that was one of the cases I had that kind of resulted from possible criminal acts, even though nobody was ever charged. Well, eventually the UCLA, one of the UCLA people, one of the alleged black doctor who was not a doctor, he was eventually charged, I believe, and convicted or pled. I think he pled or was convicted. I'm not sure which. But so there are cases where there's a criminal event or a possible criminal event, and then a civil case arises. So I've had experience with that. And I was just telling Golf before we came on that the Elliot Rogers, the incel in Santa Barbara who shot up all these people, I handled the civil case on behalf of the family, along with the firm that I was with. But I was
And
assigned to the
let's
case.
specify the family just so people
No, no,
know.
no, no.
Yeah.
And I mean, it's public record, but it doesn't.
No, no, no. I mean for people who don't know. So you're talking about you were for the family of Elliot Rogers or for the
No, no, for
victim's
the family
family?
of the victims.
Yes,
Family of the
exactly.
victims.
Yeah.
Yes, I'm
Yes.
sorry.
Yeah.
Yes, for the family of the victims of one of the victims. Okay.
Yes.
So I represented, and the firm that I was with represented the family of one of the victims
Mm-hmm.
in a civil case, because, and that's where Papa Rogers came from, Elliot Rogers.
Mm-hmm.
And it's funny because I did handle it, and but it didn't go anywhere. And the reason why is because the allegations were that the sheriff should have taken away his guns because prior to this event, shortly prior to this event, um, Elliot Rogers had some kind of breakdown or something, and the
Mm-hmm.
police were called. And I think, I don't quite remember all the details, but there was an issue where they should have taken his guns away. Uh, and it didn't fly. And a lot of these cases don't fly, especially if they're against a public entity.
Mm-hmm.
Now, if it's like the O.J. Simpson case where you have a private individual and they're not convicted criminally, well, they filed the civil case and of course they won.
Mm-hmm.
But against a public entity,
It's harder.
it's those cases, they have immunity for
Mm-hmm.
everything. I mean, there's literally a statute that allows you to sue, and you can sue, but then they get to bring defenses, which are immunities. So the other case that I handled early in my career was a social services case where Jimena Orozco, she was a 5-year-old little girl, was abused by her mother and her mother's boyfriend. And the father continued, he knew this, but he kept trying to tell social services. He kept calling the police, and other people as well were calling the police, unbeknownst to him,
Mm-hmm.
because they don't share that information. And
Mm-hmm.
and what happened is eventually a social worker got a hold of the mother and the babe and the child, and so she decided, based on this checkoff form that they had, that she was to have weekly parenting meetings with the social worker. However, that form was filled out totally incorrect. And if she had filled it out correctly, that child would have been taken out of the home that day. So what happened is the mother was living in motels, and she would call and leave her, like, I'm here at this motel, I'm here at that motel. And not to mention that they should have taken the kid away, but they even messed up on the weekly visits because the mother called and told them she was at a certain motel, and the social worker who took the call wrote it on a Post-it note and forgot to input it into the system.
Oh,
So
wow.
the little girl got lost.
Oh,
They
goody.
didn't know where she was, so the social workers couldn't find her. Then 3 months later, the boyfriend of the mother shows up here in Anaheim, Orange County, shows up at like 5 a.m, asking for help and carrying Jimena Orozco in his arms. And he shows up at the grocery store, Food for Less. And so there just happened to be a nurse in line who just got off the graveyard shift. And so she came over to try to help, and she just turned over and she threw up. Because the little girl was already in rigor mortis. This guy
Oh
had been
my
driving around.
God.
This guy had been driving around on drugs, and literally, she had indentation marks of being, and this trigger warning.
Yeah.
She had indentation marks of being in her hands, and that she was like
Oh.
shackled.
Oh no.
She was all, yeah. So of course it's the mother. Well, the crazy thing is that the father had taken her to 3 months before had taken her to a therapist, and the little girl disclosed to the therapist that she was being sexually abused. She would say
Mm.
that the boyfriend would cover her mouth and do things to her. And so, of course, the therapist, who was an intern, still therapist, she reported it immediately to social services. Well,
Mhm.
that report went, and the main social worker saw it and said, "Oh, I know this case. It's a custody battle. This isn't the and this isn't the." She just filed it away.
Oh,
So they
poor girl.
violate. So that's where we got them, because they violated their own policies, where it says if you get a report like that, you must
Follow up.
go out within 24 hours.
Mhm.
Okay. And check. And they didn't. Uh, so that was another way we got them.
Did the
Um,
child survive, or what
no,
happened?
she died.
No.
She was dead.
Oh my God. Okay.
Um, and so that was a huge case here in Southern California.
Mhm.
And so it arose out of the criminal acts of the mother, like criminal neglect or neglect of the child,
Mhm.
and the mother's boyfriend, who actually killed her, unalived her, I should say.
Mhm.
And our main witness to seal the deal was, in fact, the Orange County coroner. We were suing Orange County, that's the county
Mhm.
social services, but the main witness was the Orange County coroner, who said she had um, rib cage fractures
Ugh.
that would have been that were like 3 months, that were like 2.5 months old, that would have shown if they were doing the weekly visits.
Mhm.
She wouldn't have been able to laugh. It would be noticeable that she had something wrong.
Mhm.
So even if they had been doing those weekly visits, if they hadn't lost the address where the mother was at the motel,
Mhm.
if they had been doing those weekly visits, they would have noticed that she could not laugh. She could not, I mean, she couldn't sneeze. They would notice something. She would be very guarded in that area.
Yeah. Yeah.
So it was their own employee, the coroner of Orange County, who testified
Mhm.
against. I mean, he testified the truth, not necessarily against the county, but that was the truth. And so we were able to prove the case, the civil case.
Mhm.
And so they awarded money, and a percentage of it was attributed to the county, and the people who actually unalived her, or the guy who unalived her, of course, that the apportionment of fault was the majority to him and the
Mhm.
mother, because they were the ones who actually did it.
Mhm.
But still, social services was responsible for a portion of it.
Mhm. Well, yeah,
So
absolutely. I mean, the system failed her, her,
the
her
system
own
failed.
family, but also the system, of course.
Terrible. And
Mhm.
so I do have experience with those types of cases,
Mhm.
where there's a criminal element to it, and then the civil case arises,
Mhm.
and they were usually against public entities. And so it's interesting, because I know in Idaho 4 there might be some kind of civil case, I don't know, but it's always, that was part of my mm, what I did. And
Mhm.
so I felt a little uncomfortable, because I was a lot younger, and I felt like people might want to follow me. I don't know. I was just a little worried.
Yeah.
So I had a chance to work for an attorney who did medical malpractice, and I did. I went to go work for him, and I'm still at that firm, even though he passed away.
Mhm.
And I do medical malpractice. But initially, the cases I had a criminal. There was some criminal cause, like some criminal element to it, and
Yeah.
then arose civilly. That.
Mhm. Mhm.
So that's my background, and that's why I'm so interested in all of these cases. It's recently the Micah Miller case.
Mhm.
Um, you know, but I'm interested in all these cases, and the Idaho 4. Now we're talking about Idaho 4. Uh, I just I was like obsessed with that case.
Yeah, we're all floored by that one.
I mean, I
Yeah.
just finally I had to go somewhere on YouTube. That's where I ended up to talk
That's where
about.
you find like-minded people. But yes, you spoke about yeah, we're looking at possibly in the future there might be a civil case out of this. We know that the Gonzalez family has already filed
The
premature, like one of
claim.
those pre whatever it's called. I'm sure you're more
Yeah, it's
familiar.
the government claim form. Sure.
Correct. And they did that early on, knowing that, that is a possibility that somebody messed something up and they should be held responsible.
Right.
Now, they're going to have a good long road ahead of them if according to you, what's going on, and it's hard
It's
to
hard.
get yeah.
It's very hard. Against a public entity, it's hard.
Mhm.
And I've had good results. And then, like I told you, the Elliot Rogers case, the incel in Santa Barbara, that they called him an incel,
Mhm.
one of the family members of the victims filed the lawsuit for the loss of their daughter, and didn't go anywhere. And it shouldn't have gone anywhere because they had a lot of immunities. But, we tried to
Yeah.
get around the immunity. No.
I guess that's where we all learned the term incel for the
Yeah.
first time with Elliot Rogers'
Yeah.
case. So here we are years later, and they're trying to paint another person as an incel, which we will get into. So, yeah, I mean, thank you for sharing your background a little bit. I find that very, very interesting. So now people have a better understanding of who you are and what you do and the importance of your work as well.
Mhm.
And you're still doing it after what is it 24
20,
4
20,
years?
22.
Oh, okay,
Wait,
22. Yeah, because you didn't graduate. Yeah, I was thinking about when you started your process 1999.
no, so that's 1999 was when the UCI willed the body case
Hmm.
started. I graduated from law school in 2002.
Oh, okay, so
So,
you took it
yeah,
over after that. Yeah,
so
yeah,
I took it over. Why? I have no idea why. To this day, I don't know why Fred Sayer gave it to me. But
well.
I mean, I was working on it with him, but I ended up doing everything. And then when it came time where I took this deposition and it was my work, he said, "You handle the media." And I'm like, "What?" Um, because I'm really kind of shy. I don't come out here. But this Idaho 4, I swear,
Hmm.
I called into CJ's show one time, and that's how it ended up. I got on YouTube because I was so frustrated and nobody would listen to me. They're people closest to me were saying, "You're getting a little obsessed with this case." Like, you're just like, okay,
Find an outlet.
uh, yeah, like you need, and I would try to tell them, "No, but look," and they were like, yeah, they were looking at me like I was nuts.
Yeah.
And so just one evening I called into the show and I started talking to CJ, and that's how it all started. But
Hmm.
so, I could talk about that case all the time.
So can I. So can I. So let's talk about the case. Let's
All
talk
right.
about Idaho 4. I have a few questions lined up, and I want to hear your take on it, but I'm also open for anything that you want to talk about, obviously.
Yeah,
So,
yeah.
specifically to relating to this last motion to compel, I want to start it off by saying to me, this resembles a preliminary hearing. Like Anne is like, you didn't give me a preliminary hearing. Well, I'm going to give you one anyway. That's what it feels like because of all the witnesses she's calling. But that's because I'm a layperson and I'm not really familiar with it. But did you have that thought in your head as well? Or is that something like, no, that's
Well, it's okay. So let me just explain a couple of things. In civil cases, when we do a motion to compel, we don't have testimony. Okay. But in terms of like weird cases like the UCI World Body case, where we had the Anatomical Gift Act that was like poorly understood, we would get a declaration from an expert as to why we would need certain things, right?
yeah.
Instead of live testimony.
Hmm.
It never came to that because the judge would finally understand. But if it had come to that, then we would likely have to get an expert in world body programs, under the Uniform Anatomical Gift Act, to tell the judge why we need what we need,
Hmm.
right? It wouldn't be live testimony, at least not in California, not that I've heard. It wouldn't
Hmm.
be. So Idaho has different laws, and it's criminal law, which I have never practiced, and so I don't want anybody to think that I have. So with that said, my understanding in Idaho is that she's bringing witnesses, just like she brought the IGG witnesses,
Hmm.
Vargas, and those other witnesses. was to educate the judge why she needs the material that she's asking for, because the judge has to make the decision on whether to give her that, whether to tell the prosecutor to give her that information.
Mm-hmm.
So she's done a good job. I mean, she brought the IGG people to testify about why she needs it. He ordered, I think, part of it. And then now she's asking for certain information, technical information.
Mm-hmm.
And so, you know, the IGG and this technical information that she's asking for is not something that we all understand. It's
Mm-hmm.
not, it's not something that, I mean, I wouldn't, you know, people were like, oh my God, judge doesn't even know what the cast report is and this and that. No, they don't.
Mm-hmm.
And I'm sure Ann Taylor doesn't, well, she probably does, but the attorney handling the cases probably wouldn't know either. They need an expert. That's the whole point of an expert. And so now that I do medical malpractice, that's all I do is I rely on an expert. It's not me. I get an expert. He tells me whether there's a case or not, tells me what to ask the defendant doctor or nurse or whatever. And so with that, so what she's doing is she's bringing experts to educate the judge why she needs the certain information that she's asking for. And I don't know if you noticed, but toward, you know, the argument part of the hearing, she was going number 225 or number 335.
Yeah.
Remember they were doing, those are actual requests that she's asked for, information, documents, materials that she hasn't received.
Mm-hmm. So she knows exactly what she's looking for, just as she knows when she's asking a question of a witness or like pain, she knows the answer, because you don't want to ask a question you don't know an answer to, correct?
See, that's in trial. Okay.
Yeah.
So in a discovery hearing, you're getting information. Okay. So that's what you want. You want to educate the judge. It's not so much that you may not know the answer, but that's what you're looking for. You're looking for the answer to certain things. Where is this information? Like, if you don't have it, who has it? So it's not like a trial. In trial, you need to know, the answer before you ask it.
Yes.
In cross-examination. But this was different. So
do you believe that? I really believe she knew exactly what she was looking for.
She did.
Yeah.
And it's because she's already sent out requests, right? And they produced nothing or something that was irrelevant to her. And so she's trying to get that material. And so I have not gone through all of the discovery requests to see what she's asking and whatnot. I know Lana, Truth and Transparency,
yes.
Yeah, she's gone through all of that. She's, but some of it was sealed, so I don't know exactly. But from a technical standpoint, she's already asked for things, and that's why she was saying with regard to number 222, this, and people were like, "What is she talking about?" It's because she's already asked this in the request for discovery, like number, request for production of documents number 332. Because you start request for production of documents number 1, number 2. So she's asked for a ton of stuff. And so the discovery hearing is something that is not it's not the trial. It's not, so cross-examination, you rarely heard any objections. I know that Ann Taylor objected to a question as leading
the witness.
But that was okay, because she had, it's a discovery hearing. It's the goal is to get information. It's not, I presume that maybe she objected because she does trials and she's so used to objecting. But that was the only objection I heard. And I think it was probably just instinct that, because that's their witness. Officer Payne is the prosecution's witness. So she called the prosecution's witness to get information on where these things are that she needs.
Yeah.
So yeah.
going into that, like, what do you think? Like, to me, it looks like she has to justify every request she makes, every motion that she puts in. It seems like there is a reluctancy to hand over evidence, and she just have to, as I
Yeah.
say, it's like a justification process that she has to go through and do that for the judge, which is a little bit. Is that common that that happens, that you have
Well,
to justify every little thing and why you need it?
well, I'll say this. First, let me answer your question about whether it's like a preliminary hearing.
Hmm.
Remember, yes, I question.
Yes.
I want to make sure I answer your question first.
Yes.
So I'm not sure that it's like a preliminary hearing, but I know that Cy Ray said something like, this is not good practice for probable cause when you're looking for probable cause. He said
Hmm.
something like that. So that might go toward possibly something that would come out in a preliminary hearing.
Hmm.
Uh, but I think this is like a fraction of what a preliminary hearing would be.
Yeah. Yeah. It just felt like it because of how she's doing it. She's presenting one witness after another. She's putting now, this is the second police detective or whatever they are,
But you think
lead
she's
investigator in front of like the public, the media, so that the media sees it as well. Because obviously there's a part of this that I think she's also trying to paint a picture of what could possibly have happened, because the media is painting that ugly picture of Koberger already, and I think she wants to sway people's minds a little bit in that sense as
well, that
well.
could be it
Hmm.
too, because it's a public hearing. I mean,
Hmm.
she
Yeah.
and everything that's been said about her client, she might want to put some stuff out there,
Yeah.
to
Yeah.
balance it. But
Yeah.
so 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 in a preliminary hearing, they produce evidence. Uh, they produce evidence to make sure that the case can go to trial. In other words, they prove up what's in the probable cause affidavit, is what my understanding is
Hmm.
in a preliminary hearing.
Yes.
Okay. And so the judge decides whether there is enough evidence. It doesn't have to be in the probable cause affidavit, because you find other stuff outside of that.
Hmm.
So it's not just proving up what's in the probable cause affidavit, but finding out if there's enough evidence, whether in the probable cause affidavit or subsequent to that in the investigation, to
Hmm.
hold him over, to keep him for trial.
Yeah.
Okay. So it is kind of, maybe some things that came out might be like a preliminary hearing, but I know in some comments when I was watching the hearing, they're like, why don't you ask her about Dylan? And, you know, and it's like that,
Hmm.
this is to get specific discovery requests.
Correct. Yeah. There's a
Um,
difference. I mean, she can't do that. And why didn't they? I've heard, why didn't they talk more about where Brian's alibi? And I'm like, has nothing to do with it. And they did inadvertently. They did talk about Brian's alibi, and the reason why we all know now he hasn't put the full alibi out there. But we'll get into that later.
so okay, so I
Yeah.
answered your question about the probable cause. The second
Yes.
question was, you asked about,
Justifying, like,
yeah.
to me this is a little bit like over the top of justifying to the judge, to a judge, why this is evidence that they used in the probable cause affidavit. So she's pointing that out to him even. So why is he so reluctant on helping her with producing that material that they used against Brian in when they arrested him?
So my thought on that is, like, in criminal law, I just have a general understanding, because like I said, I don't practice criminal law.
Hmm.
My general understanding is that in criminal law, they give everything to the defense. Like, it's an exchange of information.
Hmm.
If the defense wants more information, they ask for specific requests. Like, if it's a technical thing, if it's, like, let's say it's DUI, and so you want results of certain, you want to know how the lab technician came to the result, or if it's a blood test.
Hmm.
But normally they exchange all the information. So you get all the information. If you don't, you meet and confer, you try to get more information. And then if it's not forthcoming, you file motions to compel. Okay.
Hmm.
So So the judge usually doesn't get involved in the discovery hearings unless one party is either not producing it
Mm-hmm.
or is objecting to it. Okay. So in this case, there's a little bit of both. They're saying they're going to produce it and they haven't produced it.
Mm-hmm.
And they keep saying, well, TUI and the FBI. And, initially I had forgotten about the TUI exception
Mm-hmm.
when the FBI is involved in a local investigation, because the rule is that, you have a right to confront your accusers. You have a right to, talk to everybody who was involved in the investigation. So if Moscow, Idaho asked the FBI for help and asked the Idaho state law enforcement for help,
Mm-hmm.
well, then technically they step into the shoes of the local law enforcement. Okay.
Mm-hmm.
So their investigation is part and parcel with local law enforcement. They're
Mm-hmm.
supposed to be, local law enforcement is still in charge, but they're supposed to be working together
Mm-hmm.
because they're all trying to get evidence to solve a crime. So in this case, they did ask for help because it was an awful case, a big, I guess they considered it a big case, which it was. And so, with the IGG and all this technical information, it's become a very complicated case.
I mean,
So
not really, honestly. I mean, if it's been used in the probable cause affidavit, is just my point. And if it's being, this is what we had to arrest Brian Kohlberger. They need to produce that material, whether being IgG or complicated or not
right,
complicated,
and
right?
that's where I was.
Mm-hmm.
That's what I said.
Mm-hmm.
But there are exceptions to where the FBI is not going to produce anything.
Mm-hmm.
But when those exceptions come into play, if there's no other evidence that can hold him, then you got to dismiss the case.
Exactly. So it looks like everything that is important in this case was done by the FBI. So the IgG, the CAS reports, the what else am I missing? Like everything that's important in this case is linked to the FBI, even down to surveillance parts, right?
Yeah,
So
I heard
that
that. Yeah.
they can't just withhold it on that basis, all of it. See what I mean?
Well, they can, but that means,
They have no case against him then.
and it's happened. I mean,
Mhm,
actually, I got into a discussion with CJ, and he was right
mhm,
that they can even withhold evidence for trade secret purposes.
mhm,
But guess what? If they do, and there isn't enough evidence to convict the person otherwise, they got to dismiss the case.
well, yeah, yeah.
So the
So
TUI exception kind of threw me for a loop because I
mhm,
I learned that, but I forgot about it because I don't practice criminal law.
mhm,
So while I know that one of the attorneys for Brian Koberger talked about the TUI exception is not a bar to getting stuff; it's a procedure or something.
mhm,
And the reason why is to make sure that the FBI knows what's going out and coming in or something like that.
mhm,
I'm not sure. She relied on some law, some case law, and I'm not sure about that. But so yes, a person who's convicted of a crime, they're entitled to what the FBI has unless the FBI raises exceptions. So it seems that they are raising an exception.
mhm,
Uh, and I'm not sure. And here's where I don't know. There's a lot of stuff about these hearings that I don't know. And what I don't know is whether or not there is a legitimate basis for the FBI to withhold the information
mhm.
and not give it to the prosecutor. But based on the hearing with the
Cyril.
officer Maury,
Oh, Maury, yeah.
where he said, I was just asked yesterday to look for this stuff or whatever.
Mhm,
Okay, no. If she's been asking for it, the prosecution has to ask law enforcement to get it. They
mhm,
don't do it like right before a hearing. Okay? That's bad faith in my opinion. Okay?
mhm,
I don't know whether it's prosecutorial misconduct, but it's certainly bad faith.
Mm-hmm.
If somebody's asking you for discovery, the attorney has an obligation to do a reasonable investigation, and a reasonable investigation is to ask, where
Mm-hmm.
is it? Can you provide it to me? And then the law enforcement's going to tell the prosecution, I can't because of this and this.
Mm-hmm.
And then the prosecution's going to tell defense counsel, I can't produce it because it's this and this.
Mm-hmm.
So it sounds to me like there's a lot of things that they don't have because, again, the prosecution said, or, we can't produce what we don't have.
Mm-hmm.
Well, there's a difference between what they don't have and whether it exists or not.
Correct.
So I know that throughout this discovery process, Ann Taylor has been trying to get them to respond with, it doesn't exist, especially
Mm-hmm.
with the IGG, because the FBI has certain protocols and rules they have to follow when it comes to that. And if they didn't, then they're in violation of their own rules.
Mm-hmm.
So if these things that their policies say have to exist don't exist, then they violated their own rules, and she can try to dismiss the case on that ground.
Yeah. So you think she's working up to a dismissal?
Well, and I don't know the procedural rules. So she's already tried that, right?
Well, she did it. She tried to dismiss the grand jury indictment, but she
Yeah.
hasn't tried to dismiss the whole case against Bang. So we still haven't seen that part yet.
Right. So the procedure part, I'm not sure. I think that she's getting information to do that.
Mm-hmm.
But I'm not sure about when you can do it, because a lot of these things are procedural.
Mm-hmm. Yeah.
And
Yeah.
like, for example, the alibi.
Mm-hmm.
Now, Andrew Myers and I did an episode on the alibi,
Mm-hmm.
the statute. It's a procedure. It's so that things go smoothly. But at the end of the day, there's so much wiggle room in that statute that if a witness comes and says, I was being quiet because I didn't want to get involved, but I saw Brian Koberger at the store at this time,
Mm-hmm.
the judge is likely going to have to let that person testify.
Correct.
So it's a procedural thing. So I don't know the procedures. So I don't know. I mean, I would think that she's working up to it, but I don't know.
It seemingly looks like that, and people are like, why don't they just release him right now? And I agree with you. It's a procedure. You have to go through the steps. You can't just do it like right off the bat. But so she's working her way, like clarity, form that clarity behind it, and I think she's doing a damn good job of it for what we've seen so far.
Yeah.
All right. Yeah. All right. So that was actually my next question. To dismiss the charges, at least what we've seen in the PCA and probably other things as well. So here's a thing that was brought up in your last show with Andrew Myers, and that I found so interesting that I think what's her name said, who was on there, she was talking about they gave the defense exculpatory evidence of the cast report, but nothing of the exculpatory evidence of other things, and why. And oh yeah, forensics frenzy is her name. And I thought that was a very good catch. Like, why do you think that is? That they're like so open-handedly, here you go, you can put us in the doghouse over the cast report, but we're not going to give you anything else. Have you noticed that?
Well, I have, and I think forensic frenzy knows a lot about that.
Mm-hmm.
She's a forensics type of person.
Yeah.
But I'm a law person, so
Yeah.
so my thinking is, and this is just my thinking, is that the technology with regards to the IGG and with regard to the cast report and all of that might be complicated for jurors to understand.
Mm-hmm.
So, and Andrew Myers showed an email from Mr. Gonzalez.
Yeah.
That he understood the technology better than the prosecution, or something to that effect. I don't remember what it was.
Mm-hmm.
But I don't even understand all of that. So, when that information is given over, they possibly didn't know that it was exculpatory.
Yeah.
Uh, that, but in reality, that may be it, because it's a little bit complicated for most people. Maybe some people it's easy, but so I'm not sure. I'm not sure. I think what Cyree was saying is that the evidence that they have provided with regard to the cast report, which isn't complete yet, doesn't prove anything with regard to Brian Koberger's guilt.
Hmm. Well, yeah, I mean, he said a lot that was very like mysteriously pointing towards a couple of things that I'm gonna want to get into with you as well. And one of the things he said that I found very interesting was you probably remember about that $1 million car that was down there at the time.
The SUV,
Yeah, exactly.
was it $1 million car?
Yeah, he said it's $1 million, so it's not just like any car, it's $1 million car, and there is a reason that
Who
the
said it? I
Cyree
have,
said that.
see, I have to listen to.
Hmm. And he said there's a reason that they bring that out. It's just not happenstance, right? So I don't know if it was there already in the area or not, but to me it seemed a little bit like it, that it was already there. And so what he sort of referenced in that is they use it to do what is it called, surveillance. And it seemed like there was a problem with that because if they didn't get a judge to sign off on that surveillance, they sort of got information collected without approval, meaning, because they can't just go out and surveil people nilly willy. They need to get, I guess, a judge to approve those things. So they didn't have a warrant, basically, is what I think he alluded to, but I could have misunderstood him. But since he brought that up, if that's where a lot of this information is, the cast information, mainly, I think, within this surveillance portion, uh, then of course that becomes the fruit of the poisonous tree because anything from that they will not be able to use, correct, against Koberger.
Yeah, so that's an interesting. So I would have to hear the hearings again. I
Hmm.
started to hear them all. I haven't had a chance to go over them, but I think hearing everything from Maori all the way to the end, all in one sitting, would help. But who has the time, right?
Yeah, yeah.
So what I understand what you're saying about the $1 million car. I don't remember
Yes,
hearing that, but
yes.
apparently what you're saying is that this $1 million car had surveillance stuff in it.
Correct. He
Okay.
knows exactly what it is. So he knows what kind of equipment it uses, because obviously he's been there. He's been in
And,
one of them, right?
and that was a black SUV that looked
Yeah, I mean,
like
he
a,
knew exactly what it was, basically.
okay.
Yeah.
Yeah.
So he wasn't talking like that possibly could be it. He said that was it.
Okay.
That's what he found that they were using in the area. He said they do not bring that in under any circumstances unless, there's something bigger going on, right?
Okay. Yeah.
Yeah.
So
And
the issue is if there was some other investigation going on, and as a result of that investigation, they got some kind of information that Kohlberger might have committed the crime or did commit the crime,
mhm,
then is that can that be used against Kohlberger?
mhm,
And so I don't know the answer to that. But my thinking is it would I really don't. But my thinking, because I've always thought that there was a bigger investigation going on,
mhm,
and the tip that was provided to law enforcement came from somebody, either an informant or law enforcement, that was
mhm.
working on the bigger investigation.
Correct. So let's say they had that van out there. They're scanning the area and they know exactly what happened, or they listened, they tapped in on phone lines, they're tapping in on everything, right? That's going on in the area. So they're catching somebody through that. It's still
It's not a part of their investigation.
correct, but they
Yeah.
can still give the tip. And so the question is, can they use that against him if it's not signed off via a search warrant?
See, that is the question, I think. That is
Mm-hmm.
the main question. And honestly, I would think not. I would think that they can't. But I don't know for sure because
Mm-hmm.
there has to be law about this. And I
Mm-hmm.
don't know the law. So, we go back to the law. So, what is considered the fruit of the poisonous tree? Is this particular circumstance, if it did happen, if there was a bigger investigation and somehow they got information that Koberger did this crime or possibly did this crime, and the law enforcement or informant of this bigger investigation called in the tip, is that the fruit of the poisonous tree?
Mm-hmm.
So it's going to be like, is law enforcement and an informant calling in a tip, is that the fruit of the poisonous tree?
Mm-hmm.
And I don't know the answer to that. I would think that it is because they would not have that information, but for the investigation that they're doing, right? The
Well,
bigger investigation.
yeah, because even if you call in a tip like that, you're the FBI. And so, I mean, I don't know. I really don't know. I was
But what
just
if it was a
thinking,
confidential informant working for the FBI that called it in?
yeah, I mean, that's
We
exactly,
really don't
exactly.
know.
It's
Yeah.
so my thought on that is I think we're looking at two separate entities of informants. We're looking at the FBI being one of them, and I think there, possibly could have been surveillance in the area, and that's just from what Cy Ray
Yeah,
has
but he said,
pointed
well,
out.
and Cyril also said something about Brian. Oh, I'm not sure if it was Cyril, but somebody said something about Brian being surveilled or he was under surveillance. And
Oh, he was, definitely. And he was surveilled early on. Like this didn't happen. Like I think they surveilled him much, much earlier than what they're stating in the PCA. So that's, and I have to trust Cyray on the fact that he says what he's seen so far, and he understands that. I think just looking at the cast report, the messed up version he got, or the not even the report, he got the just an outline of it. Basically, he
Mhm.
knows exactly what they did. He's not stupid. He knows exactly what kind of equipment they used, so he knows all that. And he still said that what he's seen so far is very much exculpatory towards Brian, right? So I have to trust him on that, meaning I'm not sure how far I can take that surveillance, illegal surveillance. Maybe they did part of it illegally. I don't know when it started initially. They were definitely surveilling him. That
Mhm.
I can bet my everything on that.
And here's the thing, when you listen to an expert, because now I do medical malpractice, that's all I do is listen to an expert.
Mhm.
So when you listen to an expert tell you this information, he's the expert, right?
Mhm.
So you can believe him or not believe him.
Correct.
Okay. But the thing is, they didn't cross-examine him in this. In other words, it's like the prosecution is really not objecting to this information,
Mhm.
because if they were, they would cross-examine the expert as to why they shouldn't produce it and why it's irrelevant. They didn't.
Mhm.
So to me, it seems like they're not. So when the defense is asking for discovery, they're not saying we object to it. They're saying we don't have it, we can't get it.
Mhm.
Now, I haven't heard that it doesn't exist, but they're saying we don't have it, we can't get it.
Mhm.
So what?
Or we
And
don't know where it's at.
yeah. So what? And yeah, or they're probably saying we don't know where it's at. That
Mhm.
nobody's telling us. Like
Mhm.
like for example, if I'm a prosecutor and I'm trying to get after some information and I'm asking the law enforcement officer, where is it? I don't know.
Mhm.
Okay, well, who knows? And so that's what the
Go to
prosecutor.
the evidence room and find it. Go through
Yeah,
thousands of hours of video. And of course they know where it's at. They know exactly where it's at, right? They have it lined out.
but
But
think
it's
about
like,
the prosecutor. The
yeah.
prosecutor's trying to get it. So
Mhm.
in fact, they're not. If they were objecting to her getting it, they would be cross-examining Cy Ray as to his why it's relevant in the first place. Why,
Mhm.
like, and the fact that it's protected and why they shouldn't release it, but they didn't.
Mhm.
So it's almost like they're saying we can't get it, we don't have it, and so there's going to be an order, hopefully from the judge, that's going to say that it needs to be produced so
Mhm.
that the prosecutor can take that order to whoever has it and say produce it.
Mhm.
So
Exactly.
yeah, so I'm just wondering when that order is going to come out, to get that information, because Brian Koberger's in jail, and somebody asked me, isn't that illegal that they don't produce it? Well, I don't know about like illegal, but it's certainly a violation of his constitutional rights if and when we get the final cast report and it exculpates him and there's no case. Well, yeah. I mean, that's why it puzzled me that Judge said, could it be that the cast report is in progress?
It is. It is. It is in progress. That's what the prosecution said. Even when they had the last hearing, towards the end, she did say it's still in progress. And what they're doing is, my belief here. I'm just, this is just me spitballing this. My opinion, from what I gathered, is they're trying to build around Koberger's alibi. So whatever they're going to produce, and that's why they're waiting. So, that's another question I want to come back to later on. What came first, the chicken or the egg, right? We're in that situation. What came first? In this case, they were supposed to produce I believe, the cast report before the alibi was due. Cast report was due in March 31st, something like that.
So this judge doesn't understand that, like, and I'm taking your word for it because I can't remember, but I know the cast report was ordered to be produced. Some things were ordered to be produced and they weren't.
Correct.
So this judge, he made an order and it wasn't followed. For whatever reason. Maybe it's not the prosecution's fault. Maybe the prosecution did ask for it and is having trouble getting it. But for whatever reason, the order wasn't abided by. So he has to do something.
Well,
okay,
there's still, that was the justification for not handing it over, is because it's not completed.
Yeah.
So there you go. And that is a problem because, as I say, they were waiting on the alibi. And if
the alibi,
because they want to build, like they built this case around Koberger, right? Let's just
seems like it.
Yeah. And so if you think about that and you think about the alibi, it's like goes hand in hand. They don't want to hand over the full alibi until they have the full cast report, because then they can tweak that. I mean, Cyree even talked about how they can tweak their results depending on, whatever route he took, let's say. So they can still fit him in some kind of weird timeline, So that is dangerous. Like, they should hand over the cast report. If I was the judge, or if I would have made that very, very clear in this latest hearing. Like, you can't tweak your, depending on our alibi. And if you look at her alibi response as well, we're gonna bring in Cyree as our witness for the alibi, to prove why we haven't given you everything. And I think in what he did, he proved it, sort of.
Well, from a legal mind, if a judge makes an order and there's an excuse that it's not done yet, the judge, in my opinion, if I were the judge, I would say, why not? Why isn't it done yet?
He didn't question it. He did not question it.
Well, any judge I'm before, if they order something to be done, well, guess what? I'm going to tell my client, you better get that done and you better have it done by this day. So if it's not done, the judge's question is, why not? Okay. You have somebody rotting in jail. Why isn't this done yet?
Oh, wait. I take that back. Somebody said, I think he did too. So maybe he did. I don't know. I can't remember the part where he's questioning it.
I can't remember either, but certainly his demeanor didn't come across that way. I don't remember hearing that. What I remember him saying is that, could it be that the cast report isn't completed yet? And it's like, okay, think about your order. Do your orders not mean anything? Like, that's where I get frustrated. I get frustrated because he has control of his courtroom. And a long time ago, when he was saying no cameras because people are focusing in and out and this and that, I'm like, judge, you have control of your courtroom. You can put a camera wherever you want. And, you can do it. Yes, you can. And the actual courthouse can. I mean, now everything's live streamed. Court hearings are live streamed. So they had the power to do it, and they did it.
Mhm.
So maybe this judge feels like inferior, and he feels like his orders aren't really orders.
I
I
don't know,
don't know.
but we're going down a very dark path in this, I think, because in this scenario where they're not handing over the cast report because it's not been completed, quote unquote,
Even
but
though
they're
there was an order for it to be produced.
correct. And so we're over the timeline. What that was March 31st, I believe, is when that was the deadline, right? And then they're like complaining about the alibi, but hey, hold on a little bit because you cannot produce evidence based on his alibi after the fact. We give you the alibi. That
Yeah,
is, as I
but
say,
it
that's a
doesn't
dark
matter.
path to go down.
But here's the thing. That's why Andrew Myers and I did that show on the alibi, the
Mhm.
statute of the alibi, because in reality, the burden of proof is on the prosecution.
Correct.
So his alibi is, I mean, they're making a big deal. Oh, he can't produce his alibi. He knows where he was. Why? Okay, it doesn't really matter, because at the end of the day, that statute is so wishy-washy that it's a procedural one.
Hmm.
It there's exceptions. A judge has to make an exception. I mean, this guy's going to go in front of the firing squad. What the hell? You're not
Hmm.
going to let a witness testify? That's an appeal. That's
Hmm.
a oh. I mean, they get in the death penalty case, they get an automatic appeal anyway.
Correct.
So everything gets looked at.
Hmm.
So the alibi statute is just, it's a procedural thing that you have to do this for this reason, but there are exceptions, and so it's really an, a nothing burger, because you can get your alibi by this time. You know, you're supposed to get your alibi by this time, otherwise you can't produce it.
Hmm.
You can't produce it, but yes,
Hmm.
you can, because there's all these exceptions.
Hmm.
And
Exactly. Well, nobody points that out. There is not, if you look at
yeah, we
mainstream
did.
media, well, you did, yes, you
Andrew and
guys
I
did,
did.
exactly. And that's where it's a little bit dangerous because they're deceiving the public, thinking, oh, this is like it's got to go this way or that way, and if he can't produce his
Well,
alibi, then of course he's guilty, right? So that's the picture they're painting in the media with
and
this.
yeah, it's not like that. No,
Yeah.
and as a judge, if you had, and in a place like Moscow where people probably don't want to talk, if a witness came forward and said, "I can't stand it anymore. I feel so much guilt, but I saw him at this store at this time,
Hmm.
and I have to say this," you think the judge has to let that person testify, and then that person's credibility becomes an issue, but the judge has to.
Hmm.
It's we read the statute. Look at, I mean, it, there have, in the interest of justice or something like that. I mean, it has to. So it's just a procedural thing. So
Hmm.
I think the, with regard from my standpoint with the judge, I feel like, you know, he shouldn't be making orders if he's not going to, if there isn't
Stick
going to be
to them.
a consequence to his order.
Yes. Yes,
So I
exactly.
understand when he said that you may be overestimating my powers, my authority or powers or whatever. Okay, I think if we're telling him you need to take the death penalty off the table, okay, that may be overestimating his powers because a lot of factors go into that.
Hmm.
But with regard to excluding evidence because it's not produced before trial, he has a power to exclude it. And he also has the discretion to allow it.
Hmm.
So so he does have that power. So when he says, you know, in regards to producing evidence, produce something that needs to be produced in discovery that wasn't, and then the day before trial it's produced, like the
Well,
day before the hearing, this
he
guy suddenly finds what.
yeah, no, but he didn't. So he left out the portions of the discovery that they were looking for. So in technicalities, he didn't produce it. He produced a part of it. So they still got a draft. There isn't a full report because this dude don't know how to do a full report, right? So they did not produce it. They cannot claim that they did because they did not, unfortunately. So,
And it wasn't produced per the order of the judge in a timely manner.
mhm,
Okay, now he has discretion to allow it in, but
mhm.
he doesn't make that point. He basically ignores his order and says, could it still be in the process? Is it still in the process? Okay, you made an order. Your order has to have consequences. Otherwise, you're gonna be run. he's going to be run over. I mean,
Mhm.
his orders have to have some consequence, even if
Mhm.
it's chastising in court for the attorney. I mean, literally, I've been involved with complicated discovery things, and with especially with that UCI Will body case, there's so many people, other attorneys representing. I mean, huge. So what they did in that case is they had a court reporter who, a service that was the depository for all of the discovery, so all the people in the know could look and see what was produced, what wasn't. And actually, Andrew and I talked about that on one of his shows. That
Mhm.
yes, it's called a master in where he's in Connecticut, and it's called a discovery referee
Referee,
here
correct. Yeah,
in
I saw that.
California.
Mhm.
Yeah, so this could be solved by having something like that. But I don't know if it's done in criminal law. I don't know. But the
Mhm.
point is that his orders have to have some kind of consequence, and if they don't, then it's meaningless.
Mhm.
Okay, so if something isn't produced, okay, because there was an order and it wasn't produced, that's why she says I'm going to be filing some motions to suppress.
Suppress,
And
yeah.
I don't know if it's the same as a motion to exclude evidence because it wasn't produced in discovery,
Mhm.
but even still, if there's a good reason why it wasn't produced in discovery, the judge has discretion to allow it, but he
Mhm.
also has the power to exclude it.
Mhm.
So,
Yeah, you said it before. He's there to protect Brian Koberger's rights, and that's his main prerogative as a judge, correct?
and to make sure that the right person gets
P-
convicted, right?
Correct, correct.
He's the gatekeeper of what comes into evidence and what
Mhm.
does not.
Mhm.
And you can't be scared of going up on appeal because guess what? You're going to go up on appeal anyway. This is an
Mhm.
automatic appeal. Death penalty
Correct.
is automatic appeal.
So
So
what you're talking about too a little bit, is that what you were calling spoilage? I think you referenced that as what was spoilage of evidence?
okay,
Uh,
so yeah,
Spoliation of evidence, sorry.
so if what is being requested in discovery existed at one point and no longer exists
Mhm.
because it was misplaced, destroyed, or otherwise unavailable for whatever reason, and you can't get it, then that is something that is called spoliation of evidence. Now, it's one of these things where in California, in civil, and it might be in criminal too, but I don't know because I don't practice criminal law.
Mhm.
There's a presumption that whatever is being asked for that is lost, destroyed, or otherwise unavailable, there's a presumption that it was not favorable to the party that was supposed to produce it.
Mhm.
So the jury can presume that it was bad. Now, that other side has the ability to rebut the presumption, but if they don't, then that presumption stays that it was unfavorable to that party. So they can take that into account. So when the defense was talking about spoliation of evidence,
Mhm.
that's what she's talking about, that this existed at one point and there's proof that it existed at one point.
Mhm.
Not that it didn't exist, like, it's not like if they didn't take notes initially and that's it, but if there's proof that they did take notes or they did do a certain thing, and that thing was not saved, was not kept, was destroyed, or made it otherwise unavailable, then that's like spoliation of material evidence.
Mhm.
So that includes exculpatory evidence.
Mhm.
So, and here's the conundrum is what is exculpatory evidence? And I'm sure there's case law that talks about it in Idaho that defines what is exculpatory evidence. Like, for
Mhm.
example, they saw a video and they didn't see Brian Koberger on it. Are they obligated to save that video because it's exculpatory evidence? I don't know the answer to that, but I'm sure there's law on it in Idaho.
Would they have had to use it against him, or
I'm not
just the mere
sure.
fact that they didn't produce it, or they destroyed it, or didn't produce it to the, is what you're talking about?
Yeah, yeah.
Mhm.
So, but the issue is what is exculpatory evidence? Once you
Mhm.
define that, and then you define that it did exist at one point and now it's gone, then that is like spoliation.
Mhm. Okay. Well, thanks for clarifying that, because I had, when you were talking about it, I was like, oh, that's so interesting how these little puzzle pieces, like every word they say, it's like, wait, 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 I have to know about that. you know,
Yeah.
when they have
So,
these hearings, it's good to get clarification of what does this actually mean in this case.
and that's the question. What is exculpatory evidence? And
Hmm.
we have to know that it's defined by statute or case law. And,
Hmm.
it's a bit over my head. I mean, not over my head, but I haven't done the research into it. So
Yeah.
you know,
So everything is different when it comes to definitely everything is different when it comes to a death penalty case because they have to double up on things, correct? And
well, they
it's
have
like,
to have sufficient so that's why you have to be death penalty qualified as an attorney. And
hmm,
I'm not in Idaho.
hmm,
So what they so she is death penalty
hmm,
qualified, and so she knows exactly what she's doing and what is exculpatory and what is not exculpatory.
hmm,
And when she says spoliation of evidence, she knows what she's talking about. Like,
correct.
she knows what's exculpatory evidence and what is not.
So we can
Uh,
assume that there is that spoliation of evidence in this case 100% because yes, she knows what she's talking about.
well, I can't assume that 100%, because I can't assume that. But if she said she's going to bring a motion to suppress based on spoliation of evidence,
Hmm.
if she said that, because I can't even remember now what she said,
Hmm.
because you have to watch it again and again. I
Yeah.
swear, I can't maintain it all in my head. But if she did say that, then she must know that something existed that no longer exists. And the point I brought up was the fact that he took screenshots. Maury took screenshots of certain things and didn't save the rest.
Hmm.
Um, I don't understand the whole technical part of it, but
Hmm.
is that like not saving exculpatory evidence, or is
So
it something else?
no, so yeah, I mean, I can tell you the way I understand it is it's not just that you can just take a screenshot of your report. There's
Or
yeah, there's so many
marking.
elements to it. Like you need to have like the original report, he said, from AT&T, the original, the cell tower report, and there was another thing that he needed. So when they do these reports, they put that cell tower report from that date that he originally said he did it in the PCA, because you can't take another date because these cell towers are reconfigured ever so often. So they change direction, coverage, so it has to be very, very specific. That's why Cyril said also that from what he got, it's impossible to produce what he did or say that he produced from what he gave over as evidence. It's impossible because he
Mhm.
didn't use those original AT&T cast reports. So meaning like I'm guessing the FBI never gave it to him or he doesn't know how to apply it because
Yeah,
of his 40 hours. He just doesn't know how to manipulate the data or whatever they do to get to where, they can see what they need to see because he's talking about how you have to manipulate the data to see what you need to see. So yes, it is technical, but if we're listening to what he's saying and behind every word, it comes down to like, yes, it's probably one of those where it's spoliation of evidence because the dude, not only did he not save it, like a screenshot would never even be considered evidence in this case. It's not enough for evidence. So, and
see
he
that.
used, and the problem is he used that in the grand jury indictment, which in
Oh,
itself should have been like a big red flag, right? That should have not been able to come in the grand jury indictment.
well, see, I don't know enough about the technology to say one way or another,
Hmm.
but what I do know is if Maori put together something for the grand jury,
Yes, it did.
and filed it away and then forgot about it,
Hmm.
when Ann Taylor's asking for it,
Hmm.
I think that's suspicious.
It is.
Um,
And
you,
then he
you know,
says he did it the day before, but it's impossible to, with what he did, that it's
actually, the
impossible.
prosecution would know what
Yeah.
was what was what was showed or what was given as evidence to the grand jury. The
Hmm.
prosecution would
Of
know.
course they did.
So
Of course
he
they
would
did.
know that whatever it is that Maori did exists
Hmm.
somewhere because it
Yeah.
was produced to the grand jury.
Yeah.
And Taylor probably knows because of the grand jury transcript.
Correct.
So they know. I mean, I don't know. it gets, I mean, you could go down a rabbit hole, but that whole situation about that he put it together for the grand jury, filed it away, and forgot about it when Ann Taylor's asking for it is just stupid. It's like when they said, "Oh, well, the lady at the FBI is on maternity leave and we can't get it."
She's the only one that works at the
Yeah, that's it.
FBI.
Well, I mean,
Yeah,
the
yeah.
FBI is pretty much, and if she doesn't come back, oh well, we'll never be able to get it.
Mhm.
That's insane.
Yeah, yeah. All right. So you mentioned earlier also about when I think it was Massive who said, "We'll take the death penalty off the table." Does that tell you anything related to Koberger's guilt, or you just take it as a process, a part of the process?
I just take it as a part of the process because I think if they don't have sufficient evidence for the death penalty, then it comes off the table. And I don't know what is sufficient evidence for the death penalty. Uh, Ann Taylor knows, and
Mm,
the other attorney lady knows, but I think it's a part of the process because somebody could still be guilty and there not be enough evidence for the death penalty.
hmm
That could happen.
Correct.
But so I take it as a part of the process. I think that if these things aren't produced, we're going to ask for the death penalty to be taken off the table.
hmm
Okay. And so, in regards to the judge, I think that's where the judge cannot. I think the judge cannot solely decide to take the death penalty off the table. I think the family has to have some input. I'm not sure. Not sure.
hmm
But that is a process that being death penalty certified, you would know what kind of evidence you need for the death penalty, and if that kind of evidence isn't produced, then the death penalty comes off the table.
hmm
But I don't know the details for that.
Okay. Well, I just want to know because it's going to come up. Somebody's going to mention it, obviously. Oh, that proves he's guilty. Somebody's going to bring that up, and it's good to know all these.
Nothing proves he's guilty right now.
Yeah, yeah, correct. Well, I mean, that's just part of
Yeah.
the picture they want to paint.
But people are going to believe what they want to believe, and that's their belief. I mean,
Mhm.
you know.
Yeah. All right. So let's go back to the PCA and the importance of the the probable cause affidavit. Let's start with, if you have any knowledge about, like, let's start with the importance of it as far as keeping him in the process we're in right now, based on the evidence that was laid out in the probable cause affidavit. I mean, that was his arrest, right? Came from that.
So
Um,
yeah, so the probable cause affidavit is what is needed for an arrest.
mhm,
Okay, so basically, you have to have enough probable cause to arrest the guy.
okay.
Uh, Once you arrest the guy, you keep doing an investigation, right?
Mhm,
And you get more evidence in addition to the probable cause.
mhm,
Okay. And so what bothers me is that they may have gotten more evidence in addition to the probable cause, or the probable cause affidavit may have been erroneous. But
mhm,
because they had probable cause, even though it was erroneous, it was found out later, but just from the looks of it, they had probable cause. They were able to arrest him. Now, if something in the probable cause was falsified, that's a different story. But if it's erroneous and it's reasonable that it was erroneous, that it was because they had no way of knowing, then the arrest is good, and then they get more evidence and to keep him in, and that's where the preliminary hearing comes. Is what do you have now, you know, and everything's sealed. So I don't know.
mhm,
I don't know.
Well, and
So
then to my next point, if you read that, I don't know if you can read it, but I was going to ask, like, so when we talk about this, because now they want to paint the picture, the prosecution, that, oh no, the PCA is not even relevant anymore.
well,
So,
here's the only way it wouldn't be. Okay, the
mhm,
only way it wouldn't be relevant is if they had all this information that was legit for probable cause and it looked legit, and then later they learned it wasn't legit. Okay.
mhm,
Then perhaps some of the things in the probable cause might be irrelevant, like stalking, for instance. Uh, they used that stalking in the probable cause based on the pings. Well, we heard we heard Bill Thompson say stalking was a lie. You knew that,
Mm-hmm.
Mr. Edelman. Okay. So things are going to get ferreted out. But if there's a good showing of probable cause, and I don't know if there was in this case, I don't think that there was,
Well, no,
because
if you look at it, so my question goes a little bit further, because if you look at it, it can be used as exculpatory evidence for Brian with the timeline, because specifically I can point out the timeline. According to the Linda Lane video, Brian is still driving around when things started happening inside the
that's what
house.
it says in the that's why I said, okay,
So my question then, of course, is if it's proven, if the PCA is proven to be exculpatory and they want to not use it anymore because it's inconvenient for them, or that, like, we got new evidence that they don't want to produce, can they do that? Like, is that something that they can just, like, all of a sudden snap of a button, like, this is what we used to arrest him, but we're not intending to use it, and everything in it is like pretty much bullshit at this point? um
well, here's the thing, okay? There's the probable cause affidavit, and some of that stuff might not ferret out,
mm-hmm,
okay? That's why you have the preliminary hearing, so that you know what came from what was debunked, what, but you have to have the probable cause to begin with, okay?
mm-hmm,
And it has to be on good faith. It
mm-hmm.
can't be, you know, something that is so obvious that it's wrong that you couldn't possibly have probable cause. And I've always said what bothered me the most about this case is they had the car of Brian Koberger, alleged car,
Mhm,
because they never had a license plate. And for somebody who's older like me, I mean, I know I am older, I look at things like license plates, like technology. If you have a camera that can catch you crossing a red light and get your license plate to give you a ticket, then I'm looking for that. Okay, so tell me where his car, that it was his car, by looking at the license plate. You can't.
mhm,
They can't. So, okay, then I don't know whose car it was. It was a white car. It may have been similar or not. Now, the other thing is, show me video of him going into that house and coming out and changing, or going in and coming out. Okay. Instead, what they have is a witness who says she saw somebody with bushy eyebrows in the
mhm,
house, and I
mhm.
assume that's how they got the burglary cause of action. The burglary
Yeah, yeah,
charge, that he broke into the house.
yeah.
So it's flimsy as hell to me. And I've always said that the probable cause affidavit provides his alibi, because if they're going to claim that that car is his car and he was driving it, then he was going in another direction when the murders were being committed.
Mhm.
So that's his alibi. It's in
Correct.
the PCA.
But can he still use it? And
It-
so are they, and
And
then
who
somebody asked,
knows?
are they criminal sanctions for all of this? Meaning they put all this in the PCA. That's not correct.
Well, that's the
And
thing.
arrested him based
You
on
have
that.
to have a good faith basis. And from what I see, it doesn't seem like they had a good faith basis. It seems like they put this together and they didn't realize, um, I don't know what they thought, but they put
Mhm,
this together and they have this map in there. They show a picture of an area. I can't even understand it.
mhm,
But something in that probable cause has to have something legitimate, and has to be in that probable cause affidavit that would allow them to arrest him. Now,
mhm,
my issue is not just the arrest, but how he was arrested.
mhm,
Okay. Because you have the Lisk killer who was arrested in front of a store with people in suits and no big deal, and they just arrested him.
mhm.
Brian Koberger, on the other hand, they broke down his house and they went in there, 3 a.m. or whatever, early in the morning. And I mean, what did they
And
know they had to
and they
do?
have the Lisk killer. They have on camera too when they arrest him, and that was in the middle of the street. Like, they
Very
just walked right
peaceful,
up on him, and there you go. But
very
no,
peaceful. No,
Brian is
but
like all hidden
what would
under.
warrant that?
Yeah.
That's what I want to know.
Mhm.
And so when judges sign, like I've said before, when judges sign off on these arrest warrants and things, and they look at probable cause, they believe they have, if it's under sworn penalty of perjury, they have to believe the officers because they're signing it under the penalty of perjury.
Mhm.
So, when it comes to DNA, judges are not experts in DNA. They see DNA and they think, okay, I believe what you're saying and I'll sign it. they don't understand all this technology with the cast reports. A lot of them are older, they're old, and they don't understand all of it. But they have to believe that what is said in the affidavit is true because they sign under the penalty of perjury, so they sign it. So whether there's criminal sanctions for that, I I'm I would imagine, but I don't know. I don't know what they would be. But it's a violation of Brian Koberger's right if what's in there was done in bad faith.
Mm-hmm.
And certainly he could sue civilly for the violation of his rights.
Mm-hmm.
So I know that much, but I don't know if, like, what crimes the police and perjury, I guess, for writing something that wasn't true.
Yeah,
Uh,
but let's face it, there'll never be any consequences for that anyway, really.
no,
So what you're looking at, like you're saying, I think you're right. It's probably a civil case in that sense,
it's a
because this is
violation of.
probably not the first time this happened. And to be honest, it was a good comparison to Gilgo Beach, the list, how that happened. I mean, if you think back a couple of years ago, what corruption surrounded that case. So I think that in this instance, they knew that they have to bypass all that corruption and prove everybody wrong, because how many years did it take until they again went back to him? They had all this evidence on him
Yeah.
way back
So,
when, and it was just shrouded in corruption.
and so they arrested him in front of people. It was just very calm, peaceful.
Yeah,
Just
yeah.
God.
I
But
mean, they
no, Brian
knew, they
Kober, on
knew.
the other hand,
Yeah, no,
he had
Brian
the
Koberger,
whole
they were,
SWAT team,
not only they let him drive through the country
and
and
every time
have a vacation with his family, and
And every
it's
time I
it's
see
insane.
him, I mean, he's never said a word. Okay,
Yeah,
he's not like people, these criminals who are being charged, that they're talking to everybody on you. They're talking and they're saying, "I didn't do it," and no, he's never said a word. Okay, and every time I see him, I see anxiety. I see, like, I mean, the
he's
only time
yeah. I mean,
he,
it started with he looked like a scared animal, like an animal in the woods that people are chasing. And when
well, he did
everybody's like, "Oh,
look
look
pretty
at him, he looks like he's
dangerous.
so smug." No, hell no. He looks like an animal being chased, like literally.
He
And
was,
he was
I
scared to death. I can tell you that much. That.
well, and I also, I don't know, I don't know him, but I get the sense that maybe he's kind of like what people say, a germaphobe or something. I don't know that to be true, but I do know, and here's where ex
Make him a killer.
well, I've taken care of people with anxiety,
Yeah.
or back when I was a mental health worker, and they have that look and they act that way. I mean, they're like so, and if their anxiety, if somebody who has obsessive compulsive disorder, their anxiety ratchets up, boy, they start wearing gloves, they start doing all kinds of shit. And so, who knows if possibly because he has a white Elantra and maybe he has some knowledge of what happened in Idaho, in the Idaho 4, that he got anxious and he started wearing gloves. I mean, that's ridiculous, because when Nancy Grace went out and said, "Oh my God, if somebody was wearing gloves, I would be he would be convicted. If they find out, the jury finds out he's wearing gloves after, to the store or whatever, that he would be convicted." And I'm thinking to
Oh, yeah,
myself,
of
what
course.
about the cops? They weren't wearing gloves. What about them?
Yeah, well,
They're the ones who should have been wearing gloves.
I have a theory. I'm going to run that by you. In all this law talk we are doing, is, because of the schooling he has and what he does, I really think he reached out and offered his assistance, and that's how he got on their radar.
It's possible.
Because wouldn't you, as like, you see that nothing is happening, and I would be like, oh hell, I'll reach out, see, and because he's had communication before with them, right?
It's possible.
Tried to work there. We've seen that email come through, right? So what would stop him from perhaps reaching out and be like, okay? And then the FBI was like, hold up a second, now
But then
he fits the profile, right?
But then there are people who commit crimes and they actually get involved. They reach
Hmm.
out. They
They
get
do,
involved in the
yeah, and that
investigation.
might have been what put him on their radar.
Possibly, but we don't
Mhm.
we don't know for sure. We don't know.
Yeah.
But
Mhm.
that's a theory. It's a theory, and there's so many theories. I mean, I would be walking before, like last year around this time, I would be walking my dog and I'd be listening to all the YouTubers talking about the Idaho 4 case,
Mhm.
and the reason why I went to YouTube is because I couldn't wrap my head around it with the mainstream media, and I started talking to everybody close to me and they thought I was insane. And
Mhm.
so I had to find somebody else or some other way. And I ended up on YouTube channels and I started listening to everything.
Mhm.
And I'm like, no way. I mean, initially I thought that perhaps maybe Brian was stressed and maybe went to go get medication, like, rugs.
Mhm.
But I don't know. This is a theory. It's
Yeah.
not
Yeah.
anything concrete. But the problem is that everything is sealed, so people speculate. What you
Mhm.
don't want to do is you don't want to bring harm to somebody who isn't involved, like,
Mhm.
you just have to be careful. But people speculate, and there's in this case there's a lot to speculate about.
Of
But
course.
I'm trying to keep it to the point where why did they pick this guy?
Mhm. Yeah, and
Why-
I'm not saying he's an informant, a police informant. I'm saying he just reached out, simply reached out and said, "There's anything I can do, I do this and this, as you know, and if I can offer my assistance, I'm here." Is more what I'm thinking. I think it was maybe done in a more innocent way than people are like thinking he's a full blown informant for the police.
well,
That.
I've thought about that too. I mean, we don't know.
Hmm.
And when you have a gut feeling about something, you tend to stick with it.
Yeah.
And your gut feeling is your gut feeling. I mean, it's because you don't know everything.
Hmm.
And that's the problem with keeping things sealed. But
Hmm.
the thing about keeping things sealed, I thought, was so that to protect Brian's
Rights.
constitutional rights.
Hmm.
But now it seems the prosecution thinks it's their it's their right to keep it sealed.
Yeah.
But Anne is not objecting. So I'm not sure. There may be reasons why both want to keep things sealed.
Well, I think Anne has been opening up more and more because in the beginning, you noticed that she was against even allowing cameras in the courtroom, right? She was very adamant about that. And it was really the judge who allowed that all because he was like, no, no, let's just keep it. And even down to when it was an issue, I think she still had an issue with it. But I believe that, and I could be completely wrong, but I've seen her turn a 360 on a lot of things where she wants to unseal a lot of things in this case. And I think it's because of the media perception of Brian, and she would like to help that along maybe and open up these documents so that people can see. Hold on a minute, because there's so much you don't know. You can't just paint him as guilty because you're tainting the jury pool. The
Yeah.
media has a responsibility just like we do, of course, but the media more so because they reach so many people. They do have a responsibility to keep it at a level of not, you know,
Right.
proving the man guilty before he's even gone to court, and they're not taking that responsibly. So they already painted that picture of him, and there's very little Anne at this moment can do other than open up more of these sealed
Yeah, and she's
documents
probably
and.
finding out that a lot of this stuff is bullshit.
Mhm.
You know, but you suspect it, but until you can prove it, then yeah, open it up. Because
Mhm.
the one thing you don't want to do as an attorney is you're trying to protect your client's right, and then you really can't prove some of the things you're saying, and you go ahead and say them, and then it turns out you're wrong.
Mhm.
So she must know now, establish certain things that she wants, that now, as long as it's not going to affect the safety of somebody involved or victims or witnesses, and time has passed as well,
Mhm.
I mean, you know, so it seems like it's a combination of things, and maybe she has more information now that she can
Mhm.
prove it, because they always say, like, when you do an opening statement, everything you say you better be able to prove. So if you don't, you look bad, and
Mhm.
the other side will point it out. So she doesn't want to do that. So to protect Brian, initially maybe she wanted to keep and witnesses or whatever else, but now that things are becoming a little more transparent
Mhm.
for her, that she's willing to open it up. But
Mhm.
I don't know.
Yeah, yeah. Well, and to that point, the way she's always claiming Brian's innocence is also very interesting to me. and I heard lawyers talk about this, and I'm sure you're familiar with that, is that you wouldn't go out and say, my client is innocent, and say it over and over again, because it is your reputation at line as well
Well,
when you keep stating that.
you would say it at trial. At
Well,
a
you would say
trial,
it at trial. Yes,
but we're not at trial yet. So
correct.
yes, it's um in closing argument at a trial, I could see somebody saying a defense attorney saying that.
Hmm.
But even still, uh, it's kind of rare, I think.
Yeah.
But I don't know. I don't practice criminal law, but
Hmm.
I've always been a true crime person.
Hmm.
Uh, and I don't know why I never went into criminal law. I got the highest grade in criminal law, but somehow I never got.
Never too late, right?
Well, it's never too late. Yeah,
Yeah.
but the drama is a little bit too much.
Hmm.
Medical malpractice is very, you have an expert, you do the case, you settle it, it's confidential, nobody knows, you don't,
Hmm. It's easy.
you're just under the radar and
Yeah.
nobody's following you. Well,
Yeah.
trying to shut you down. But this case for some reason has bothered me so much. And there are other cases like Karen Reed, but this case has bothered me so much. Like literally, I would wake up in the middle of the night. Well, maybe he was this and maybe he was that. And I'm not the only one. So I don't know what it is about this case,
Hmm.
but I don't know.
Hmm. So let me just address that one question. She says, I disagree, but because I guess Brian got into an altercation with his professor. Well, that is not proven, meaning that information we got from a woman who's on TikTok and on Twitter.
Well,
And so it's
mhm.
it's on that information is not verified. So we should be careful, with
Well,
those.
it's not. I don't know if I mean it's information that's out there. What I don't
Mhm.
it's I don't know for it to be fact, but
Mhm.
but what I will say is that if I'm correct, based on the fact that I took care of mentally ill people who were very intelligent, but their mental illness kind of took over,
Mhm.
where it just, like schizophrenics who were on medication and then for some reason they broke and they had to be hospitalized, or obsessive compulsive people who maybe were elderly and started getting anxiety and they started doing crazy things and it was, gonna cause them harm. So if he had, obsessed, if, and I don't know if he did, and I don't want to say he did, but
Mhm.
if he did, it's not uncommon for people like that to get into it with others because they want their way, they want control,
Mhm.
and so it's one of these personalities that, and I'm a little obsessive compulsive, so I know they want their way, and they get anxious when they don't get their way, and it comes across as being an asshole. Um, Question: will you ever go into criminal law? I might if I had someone to help me to follow to learn because I would have to learn the ins and outs, and I mean the law is one thing, but you also have to know other things. But to me, criminal law would be very easy because you just have to create reasonable doubt.
Would you have to go through some kind of certification on that, or
No,
you can just switch
I
gears,
could
basically,
switch.
right?
I could do criminal law right now, but
Mhm.
but I've never done criminal law, so it
Mhm.
wouldn't be wise for me to do it without somebody mentoring me or,
Mhm.
me learning a few things or working at a criminal law firm where they kind of tutor you.
Mhm.
And I'm so set on medical malpractice that I just listen to the expert. I
Mhm.
don't. Yeah, and everybody in defense counsel know me, and they know that it's the expert. It's not anything wonderful that I'm doing. It's the quality of the expert that you have.
Mhm.
So, but what anyway? What was I saying? I was talking about.
Oh, the mental illness part of,
Oh, yeah. Oh,
yeah.
so it wouldn't surprise me, that somebody who became more anxious because, and I said this when I first called CJ's show, is that this Brian Koberger, this was the first time he was away from his home on his own. Before that, he lived with his family, and
Mhm.
even his mother had posted things about, oh, my son, he's going to be on his own, and which Hidden True Crime commented on, which I thought was not cool.
Mm-hmm.
But this was the first time for him to be on his own. And even his father, I think, said something about, wanting him to have friends or something.
Mm-hmm.
So he was on his own, far away from his family. And, he was starting a very intense PhD program.
Mm-hmm.
Now, he did have a master's, but he was at home when he was going for the master's, right? So some people need that home, the stability. Even though it may be unstable, it's stable to them.
Mm-hmm.
And so this was his first time away from home. And so is the anxiety going to get you? It probably will. Is his OCD going to increase? It probably will. Is he going to have trouble with interpersonal relationships if he has anxiety? Possibly. And I could see him being very intelligent and getting into it with the professor because maybe he knew more than the professor and he knew it and it was frustrating.
Mm-hmm.
And he was acting like a jerk,
Mm-hmm.
And so you have these power struggles at work. It happens all the time. This is
Mm-hmm.
not isolated incident. I mean, in law, oh my God, it happens all the time. Partners and associates, they get into power struggles all the time. And you get the person who's up above you saying, yeah, you need to change your ways. You need to adjust your attitude, or you need to do. And so then what does he do? He starts giving everybody 100%. I don't know if you heard that. That
Yeah.
may be a rumor, but according to, I think
Yeah,
one
it's
of
part of that rumor is he got better and then correct. You're right. You're right.
so it wouldn't surprise me that he had issues, but those issues doesn't make him the person who went in there and unalived those 4 students
Mm-hmm.
and made a bloody mess.
Mm-hmm.
Because in my opinion, if somebody has that OCD, and this is just an opinion from a mental health worker who took care of mentally ill people, they're not going to do that.
Mm-hmm.
They would get a, a device and a firearm or something and shoot.
Mm-hmm.
Or
From a
poison.
distance, so they
Or
don't
poison.
get that all over themselves, is what you're saying.
Yeah, or
Yeah.
poison somebody or do something like that.
Mm-hmm.
But there's also the possibility that he could have had a break, psychotic break.
Mm-hmm. Mm-hmm.
None of this is even true.
Mm-hmm.
Nothing what I'm saying. I'm just giving you things that might have happened, may not have happened. He may have not even been OCD in the first place. I mean,
Mm-hmm.
I don't know. But I'm just kind of giving my theory because at some point he is a human being. I mean, and the 4 students, they were human beings too. And so
Mm-hmm.
you have families who were told a certain thing. You have families who were told that Brian Koberger was stalking them. And then you have the prosecutor in open court say the stalking was a lie.
Mm-hmm.
Okay, there's something wrong with that.
Mm-hmm.
And I feel comfortable saying that because those 4 students should not have been murdered like they did, and Brian Koberger should not have been arrested like he was.
Mm-hmm.
Everything was so extreme in this case
Mm-hmm.
that something's up.
Mm-hmm.
And then you have a judge who may be under pressure and maybe he doesn't articulate right or whatever, but if he's going to make an order, it has to have consequences. That's why you make an order. You
Mm-hmm.
don't make an order to then say, well, maybe it's not done yet. The cast report's not done yet. Okay, but you made an order, right? That order meant the prosecution had to get on the ass of the people who are doing the cast report and do it by a certain date. They didn't.
Mm-hmm.
So
Well, and also quite the contrary, there's a little bit of resistance in him to allow it to even go that far, because at the end, when I really thought that they explained it really good why they needed it, and laid it out there for him, but he was still resistant. He wasn't like, I see your point and I understand it now. He seemed more like, well, I still don't see why you need it. It was more like that it
he
came
didn't
across.
say it. He didn't say that. I don't see why you need it. But I could see how you could pick that up from him.
Mm-hmm.
I can't say one way or another. I think it's, to me, but I do see what you're saying, that he's reluctant, that it looks like he's reluctant, but I
Well,
can't
because
say
of the questions he's asking,
that.
right?
Well, yeah, but on the other hand, what I yeah, no, yeah. I'm thinking about it. It does seem like he's reluctant, but I
Yeah.
think to me it seems like, oh my God, he's so tired. Like this is just too tedious. You have so many requests. Like, is this necessary? Like I have other cases. Remember when he said,
Mhm.
I have other cases
Mhm.
because he is under control. He is under not under control. That was a Freudian slip. He's under the control of somebody. No, but he is under pressure with the caseload that he has, I'm sure, because he does all kinds of things like DUIs, all kinds of stuff, drug trafficking, drug cases, and so this is the main case, but sometimes the little cases take away from what you're supposed to be doing in the big case. So maybe he just feels like, Jesus,
Mhm.
like, why are you pressing so hard? Like he's reluctant because of the work, that he has to do. And he takes forever to, well, I don't know. My
Mhm.
Idaho's different, but he takes a while to give
Well,
out these rulings, and maybe it's a
yeah.
good thing. Maybe it's a bad
It's
thing.
not that Idaho is different. You look at the Lori Day Vallow and Chad Daybell case, and you compare the judge, Boyce, I think was his name, and he was fantastic throughout the whole procedure. Like he was so on point on everything, and there is
I
a
didn't follow that case.
certain level of assurance you get from a judge that he knows what he's doing. You understand
Well,
what I'm saying? In the Murdoch, did you watch the Murdoch case? And the
I
judge in
couldn't because he was a lawyer.
so
And
there
oh,
are certain judges that have that, they give that off. I guess it's years of experience, I assume, and supposedly Judge has years of experience, but he doesn't like it doesn't come out of him in his assurance or how he
he's in
asks.
control.
Yeah, he's in
He's in
control.
control.
Yeah, yeah.
And he can make a decision. It could be a wrong decision, and
Mhm.
it'll get overturned on appeal, but he can make a decision.
Yeah,
Okay.
but he can't be afraid of making those decisions.
Well, he shouldn't be,
Mhm,
because this is an automatic appeal. No matter
mhm,
what you do, it's going to get reviewed. So you make a decision, and you make it based on the what. So the only thing I can say, and I don't have criminal law evidence, probably isn't much different than civil law evidence. I don't think there might be a couple exceptions, but it's pretty much um, you know the same
mhm,
all around. So evidence is something that I know, so that I know what objections I have to make on the spot.
mhm,
Like when I'm in a trial, objection.
mhm,
So I know that, like, I know it. It's intuitive. You have to know it. So I know that this judge has the power and the authority to make a decision, even if it's wrong, and everybody has to follow it.
mhm,
And it may go up on appeal and get overturned, but that is the power that the judge has.
mhm,
And I always felt like, look, even judges get overturned, even judges are wrong. So we're human. I mean, we're human. We're not perfect. Judges are not perfect. But what he does have is the power to make sure that what comes into evidence is proper, is what the law is going to uphold. And sometimes judges make the wrong decisions, and guess what, that's why the court of appeal is
mhm,
available.
mhm,
So even judges make mistakes. So anybody who's worried about making a mistake, think about that. Even judges make mistakes.
mhm,
We're not perfect. Nobody's perfect.
mhm,
And for anybody to think that judge is perfect and he's going to make the perfect rulings, that's unreasonable. But it seems like he's not making, and like he's not recognizing the power that he does have, or the authority that he does have, and he's certainly not he's not putting consequences to his orders,
mhm,
even if that consequence is chastising a lawyer. There was an order, I could hold you in contempt for not following this order, blah blah blah, and then letting it go. But
mhm,
there's a consequence to the order. There's an order, so it has to be followed. If it's not followed, then there's a consequence. And once there's a consequence, then the person subject to the order can give the reasons why they didn't follow it.
mhm,
And the only thing we keep hearing is we don't have it.
mhm,
We can't produce something we don't have. It's
Mhm.
like, why don't you have it? And this is what Ann Taylor is trying to do. She's putting up the people who are supposed to give it and they don't give it, and why they haven't given it. Because they forgot about it, because they prepared it for the grand jury and then they put it in a fountain. They forgot. When they asked
Mhm.
for it, they forgot. They somehow forgot that they put it together for the grand jury.
Yeah, it's
Slipped
crazy.
my mind.
Yeah, because honestly, there's only one consequence in all this, and that is actually on the other side is people are blaming Anne for like she's prolonging this process and by doing this. So that's the consequence. It seems like from
Mm.
outside for the families and for the media is like this is Anne putting on a show, right? So that's the only consequence we see is Anne is taking the grunt of that consequence, unfortunately.
For some group of people, yeah, they think.
Correct.
But in my opinion,
Well, for the most, because we're a small community, this is in no way near a
oh,
big
you're
community.
yeah, and well, like in my opinion, I feel like the judge has control over the case in terms of moving it along. So,
Mhm,
like in here in California, we have case management conferences, status conferences, where the judge is actively, proactively saying what's been done, where are you at, are you ready for, that kind of thing to keep the cases moving along. At least that's how it used to be. Now, because of COVID and all the shutdowns and everything, the criminal cases have priority. Because as you know, if a criminal doesn't waive their right to a speedy trial and their trial comes and there's no courtroom, well, guess what? It gets dismissed.
mhm,
So I'm behind on my cases, and this is part of the reason why I had too much free time and I was looking at the Idaho 4 case and got involved in YouTube. So I don't know, but I've never had so much free time in my life. So either I'm very very busy or I don't have a lot. That's how it's been since you know.
mhm,
So COVID kind of put me in a different situation. But what I'm trying to say is that the judge is the one who keeps it moving, who
mhm,
keeps tabs, who says what is the status on getting this to prosecution and or to the defense. And the
mhm,
prosecution has to actually give status. This is what we've done. And so my thing is, and maybe this is true that Anne is doing this, I'd be calling every day. What's the status on getting me this cast report? Who have you talked to? What's been done? And then I would take notes and write it all out. Okay, next day. Did you talk to them? Did you leave a message? Okay, you left a message. Okay, next day. Did you get a call back? I mean, I would be the biggest pain in the ass, and maybe Ann Taylor is like that.
mhm. We
Um,
just don't know.
we just don't know.
Yeah.
But that's what I do when I have to do a motion to compel. I have all my notes of when I called, all the days that I called. On
Mhm,
this day I called, they said this. On this day I called, they said this. On this day, blah, 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 blah. And I have my declaration about all the attempts I did to try to get counsel to give me the information. And I still don't have it. So I think I need an order. And the judge gives an order and then the stuff comes.
yeah. Well, that they might actually need a referee, like you said,
Well,
one
that's
of those, because it seems like they're not getting from point A to point B. And if they're going to keep blaming Anne, she's going to have to do something about it, unfortunately, and ask for a referee in this case.
well, that's the thing. In criminal cases, I don't know, but something complicated like in RICO cases, where the FBI and
Mhm,
something so complicated. And I know this because that UCI World Body case was so lots of parties, lots of people, lots of dead bodies that
mhm,
were donated. I mean, and then keeping track of all the class action people and
mhm,
those who had an agreement to get the remains back, those who didn't, but heard on the news that spines were being transported and they were fresh spines and his dad was just donated and around that time, so his spine must have been one of them. Though all of this crazy shit, there's no way that you could just have it out there. There has to be a repository where everything goes in. You can see the people that need to know can see what's been produced, can see what hasn't been produced, can see what's outstanding, and can do something about it,
mhm,
because otherwise it's just mass chaos.
mhm,
Like people were asking me, what are the numbers? Like what like she's saying now number 233. Like what is that? What is that some secret? No, no, no. That's that's the number of the discovery request that
Mhm.
she asked for specific information. She's just not telling us what that information is, so it's kind of like, what is it? But they know what it is. And Judge is like, oh my God, get me out of here.
Mhm.
Um,
Yeah.
but
Sort
so
of.
so I do know. I mean, discovery. I know discovery, and
Mhm.
I know that there has to be consequences to the orders, even if it is just chewing out defense counsel. There has to be some kind of consequence, and I don't see that in this case. I see the fact that maybe he forgot he did an order. Um, it's really sad.
So if nothing changes, let's say, and it keeps stagnating and, continues like that, is there anything that the defense can do in that case? If it doesn't pick up or they don't get discovery, or other than what we're, the motions to suppress and all those things that we talked about, is there anything else that they can hold the judge responsible for?
No, not that I'm aware of, and
Hmm.
it all would come up on an appeal.
Okay.
Um, I mean, she has to go through the procedures and do what she needs to do and
Hmm.
go through the motions. And if the judge doesn't do anything, that's something that you can appeal. And she's already done that interlocutory appeal where on the, I think it was on the grand jury,
Hmm.
where the appeal went up while the case is pending,
Hmm.
and it was denied. So there's probably some interlocutory appeals that she can do that would stay the case for the higher court to decide. Probably there
Hmm.
might be a couple more that she could do, but in that case, is it worth it? And it has to be a big issue.
Hmm.
Um, but there's interlocutory appeals she can do to the appellate court or to the Supreme Court while the case is in progress,
Hmm.
possibly. Those are some things that might be options. But when it comes to discovery, that's not going to happen. She has to go through the motions, and if the judge orders something and it's not produced, and he decides not to do anything about that, then it go something for appeal. Or well, first it's if they didn't produce it and they violated a judge's order, what's the excuse for violating the order?
Hmm.
If it's a valid excuse, well then that. But if it's not a valid excuse, then it gets excluded. And if it was destroyed or otherwise unavailable because of spoliation, well, it's they get to introduce that. They get to say they didn't produce it because they ditched it or they destroyed it. So they get to say that, right?
Hmm.
That's the consequence of not producing it, right?
So they can tango for a long time, is what
Oh,
you're saying.
this is not. I mean, I know that Andrew Myers did a show on this case that was going on forever on appeals for like 20 some years. And I know, like here in California, there was a serial unaliver, Rodney Alcala. He was like the dating game killer or whatever.
Oh,
That was
wow.
Rodney Alcala, and I went to his trial here, and he was his own attorney, and this for a big part of it, and he was winning everything. Okay, he was winning everything, new trials, and he was his own attorney. He was very bright.
Oh, oh, so he was intelligent, not like what's his
Oh no, he
the
was
guy
very.
who drove into the those people in a Christmas parade.
Oh
Um,
no, 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 no,
yeah,
no,
okay, okay.
no. Daryl, whatever his name.
Yeah, yeah, Daryl
This
Brooks.
guy,
That's him. Yeah, yeah,
super intelligent,
yeah.
scary intelligent.
Okay, okay.
He represented himself for the
Hmm.
majority of the time on appeals, and he was winning. He was getting new trials and this and that. And finally, he got a new trial here in Orange County. So I went to go see. Ooh. He had a presence in court. He sounded like he was very intelligent.
Hmm.
Um, and but he got convicted eventually. And so, but it could take forever on and on and on. I mean, nobody really. I mean, the Chad Daybell case and the Lori Vallow case that happened kind of fast.
That was fast,
Yeah,
yes, for what it was, and that's I think it had a lot to do with the judge, to be honest with you.
it
Like
might have.
he was very like boom, 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 boom. So I
Well, I'll tell you, I didn't
yeah.
follow that case, and I didn't follow Murdaugh too much because he's an attorney, and I thought I'm an attorney. I didn't want to.
All
And
right.
the whole Lori Vallow case had to do with religion, and the pastor kind of like,
Oh my, yeah.
But the Mika Miller case interests me. I don't know why, but the Lori Vallow and Chad Daybell didn't interest me too much.
Well,
But
it started for me with the Netflix documentary on that one,
the
and then
what
I
I
had to.
yeah, what I found on the Netflix documentary was the Stephen Smith case. That
Mm,
interested me,
yeah, yeah, yeah.
where they all said that he was hit by a car.
Hmm.
Yeah,
And that's still, I don't know how that case is doing. I think it's still pending on some kind of level, but yeah, that's scary what happened
yeah.
to
The
him.
pathologist was.
Yeah. But anyway, I just want to say I know we're like almost 2 hours in and you're probably very limited, but if anybody has any questions, just type question in capitals, please, so I can make it out while we discuss other things here, so I don't miss it. Sorry. And I know I want to thank everybody for being here. This has been fantastic, and thank you. And I'm sorry I haven't interacted more with you guys here, but I'm just so fascinated to get answers to a lot of questions that I personally had about this case. It's very
They may not be
helpful.
the right answers, but
Sorry.
they may not be the right answers. But
Well, listen, we're getting closer because in all this, we can't forget there's a legal process, and if we need to understand the legal process for us to understand the case at this point, right?
yeah, and
So,
we have to understand that she has to go through the motions, and
mhm.
you know,
And
um,
it can't just be like, why isn't, Brian out already? Well, from judging from what you say, this can go on for years and years and years, unfortunately, for that dude. I mean, he might lose half of his life in there, before he gets out.
and the whole DNA thing too. And there's so many moving parts in this case that I swear I could talk forever. I could talk forever
Yeah.
about it. But the one thing that I want to say is that, like, so many. This was not just one person. Even if it was one person who went in and did the crime, it didn't happen because of one person. It was bigger than that.
Hmm.
I don't know what the bigger part is, and everything's sealed, but it's bigger than that.
It seems
And
like it. It seems like it. And just as like one person going in and being capable of doing this and that amount of time and while still driving around miraculously, I don't know how that happened. Like it's just impossible. And I'm not saying that it's impossible to and I'm going to use the word kill because I don't think I don't think it's impossible to kill someone in that amount of time, but it sure as heck is impossible to not leave DNA behind in that amount of time because you have no time to clean up after yourself and not bring some of that DNA with you into your car, because you don't have time to change. Let's face the facts. That car sped off.
I
So,
have no idea. Like, I think about that, and I think in my mind, I have all these thoughts, and I think, my gut, like if I had to have a gut feeling, it was like this house was ambushed.
mhm.
But I don't have any basis for that, but just my gut tells me that it was like a swarm, like there was like but only a couple of people did it, but nobody was getting out of that house. Um, a- you know, I just it just seems like that to me. I mean, I could be completely wrong, and this
Well,
is
I don't think you are because initially before they had Brian Kohlberger, there was a lot of interviews with a lot of former FBI agents, and I'm not talking about Coffindaffer, uh, uh, different from different fields. I mean, like high up graded. Oh wait, hold on. We have a couple of questions there. High up graded people, right, in that community, and they all talked about this being more than one person. So it's not like we're taking it out of our little finger. That was like from what they could tell from what they knew, that this is like impossible for one person to do this. So I trusted what they said,
Mhm.
to be honest with you, because they have experience, they've seen this before. So I don't think you're wrong per se, because maybe you heard it too. And so, it's not inconceivable that that's what happened, is all I'm saying.
No. And Tommy has a question about why
Yeah,
has
I have one before that, Jesse Stargazing, and I don't know how let me see if I can highlight it from my let me see. Oh, I can't. I'm sorry.
That's
Because I
okay.
can't go up in StreamYard for some reason. I can't scroll up, so I apologize. Oh no, I could. I could. Here.
You can read.
So this is one question. If things were destroyed and the evidence that they arrested him on are not true and accurate, can Anne ask for a dismissal? Can she go to the Supreme Court?
Yeah, so that's what yeah, if okay, so the if there was if the probable cause affidavit is lies and it's proven to be lies, not just reasonable mistakes under the circumstances, and then yeah, I mean she can ask for dismissal. I just don't know the process, the procedural part of it is how does she do that? I know she's already asked for the no, to get rid of the grand jury findings and um, based on the instruction that was given to the grand jury. I thought that was a losing argument because it is probable cause, not beyond a reasonable doubt. Beyond a reasonable doubt is at trial, not. But the statute, the way the statute was worded, she tried to do that. Then she also tried to do it on prosecutorial misconduct, where we don't know what the allegations were against the prosecution, but certainly if the prosecution knows that things were destroyed and it's proven, then uh, yeah, she can ask for a dismissal because it's like the fruit of the poisonous tree. They didn't have probable cause to begin with. It's like, if a policeman is called to a house and he goes there and he hears somebody screaming, he doesn't have a warrant to go in the house, but he has probable cause because somebody's screaming. There might be a crime going on.
Hmm.
And then when he goes in, he finds some evidence of a crime. And so he went in without a warrant, but he had probable cause. So that's a simple way to explain it. But if you have somebody who is fabricating probable cause and there's like a conspiracy and you're able to prove it, well, that's not probable cause. That's lying and that's a conspiracy and that's something that's violating this person's rights. So yeah, she can file something to get it dismissed. I just don't know the procedure or how it works or what the timing is, how many times she can do it because she keeps getting more and more information. If she didn't have the information when she filed the prosecutorial misconduct motion to dismiss, maybe now she has some. I don't
Hmm.
know, but I don't know what the procedure is. But yes, that there is a way to do that. I just don't know how.
Well, just based on the cast, I don't think she might have had that early on. But if she had that cast information, what she now knows, she would have probably won it, because honestly, what was testified to from the witness was just horrendous.
Well,
Horrendous.
yeah, and even in the trial itself, if something comes out that is a lie or there's a conspiracy, the judge himself can dismiss it.
Yeah,
Um,
correct.
because, or I mean, there's a lot of things that can be done. It's the procedural part and like how it's done. I don't know, but yes, they can do that. They can
Hmm.
ask for dismissal. It's just the procedure. I don't know.
Hmm.
And then this one.
Yes.
Um,
So why hasn't there been any consequences for Payne and the PCA lies and the prosecution for not getting the discovery over to the defense? And is it up to the defense to go through the evidence room to find?
well, well, the consequences for Payne and the PCA, we've already heard the prosecution say that was a lot. That was not true. That was, you knew that was a lie. I think he said you knew, or I'm not sure if he said lie or wasn't true.
Hmm.
Okay, but if it wasn't true, maybe they found out later that it wasn't true. But if he said you knew that was a lie, then that means somebody lied on the PCA. And I have to go back and listen to that to the hearing again because
Hmm.
I swear you have to really listen to it because after some time your mind can't hold it all together. But so if it was not accurate, that's one thing, and there's a good excuse why it wasn't accurate. But if it was a lie, uh, that's going to come out in trial, and so that the consequence would be that the jury doesn't believe Payne and renders a not guilty verdict. But the consequences in terms of what happens to Payne for lying is penalty of perjury. I mean, it would be perjury, because if he goes and puts this affidavit, it's one thing if he's reasonably mistaken. Okay. I don't know there's certainly circumstances where some officer believes this, he has good basis to believe this, but then it turns out that wasn't the case. Okay. But there's another thing where it's intentional and that they lie and they present it to a judge, and the judge has to take what they say because it's under the penalty of perjury, and they're officer, and they say they got touch DNA and they had it analyzed and all this stuff, or they say, that we found a sheath, or they say, I walked in and I saw this, all these things that they're saying, they take it because they're signing it under the penalty of perjury. If it's a lie and it comes out as a lie, then they could be prosecuted for the penalty of perjury. But guess who has to prosecute them? The prosecutor, Bill Thompson. So I don't know. But and then the other thing about going up to get evidence rooms, Forensic Frenzy had, I remember what she said. She made a good point, but I can't remember right now. But the point is no, it's not up to the defense to go to the evidence room and ask the evidence clerk to pull up this. That would be dangerous. Okay. It's the prosecution that has to do that. And the judge has to order the prosecution. That's what the order is for, when he's saying, get this. And it doesn't matter that the FBI was involved and that they did their own investigation, that they did the investigation along with Idaho. It doesn't matter, because as a criminal, if I'm accused of a crime, I have a right to confront all my accusers. Okay. So because they asked for help and the FBI stepped into the shoes of law enforcement, yeah, I can do that. Now then the FBI can give excuses as to why, the TUI exception, and then you fight it out in court. But no, that's like saying with me in these Will body cases, well, you got to go to the actual morgue at UCI and ask for this. No, you don't do that.
Yeah, you have to present the material. As prosecution, they have to present it. It's as clear as day.
Yeah. I mean, otherwise it would be haywire. You'd have defense attorneys going in and asking to see evidence. And what is it going to check out? How do you check it out? I mean, it doesn't work. It doesn't work.
Yeah, it's backwards. It's very backwards what they're asked to do. And as far as Payne goes, let me just put my 2 cents in there. He has already geared up for everything, meaning he actually said that everything he wrote in the PCA comes from the FBI. So I could tell you from that, he will probably never face any consequences. He's just
not if he said. He didn't say. Did he say that in the PCA?
He said that, and
no,
he said
he even in the PCA.
Oh, it didn't say that in the PCA. He said it in the latest hearing, that even the PCA was written with the help of the FBI.
Yeah. Well, guess what? So an affidavit or any kind of declaration under the penalty of perjury, anything under the penalty of perjury, you got to state where you're getting the information from. If he didn't put there, the FBI was involved, and based on the information that the FBI gave me, I had information to do this or to do that, or so, I instructed so and so to do this, blah blah blah. I mean, it's personal knowledge. That's what personal knowledge that led him to believe there was probable cause. Now, yeah, I mean, you can't have multiple officers writing all these declarations. You can, but it's not practical. So maybe sometimes you might have a couple of probable cause affidavits. I know there was Officer Blake. So you have a couple of officers do it, but it's based on their personal knowledge. Now, hearsay, that can come in. I mean, it's not trial, based. So, I know that one of the officers said that based on Nunez's body cam, he saw that there was a dog or something or something. Well, that's his personal knowledge if he reviewed it, right? Nunez.
I see what you mean. Yeah.
Nunez doesn't necessarily have to come out and say, I saw a dog, because you have multiple police officers, so the lead one is telling you what he did with regard to looking at what he looked at with regard to the officer, because otherwise it would be multiple declarations from all of the officers there saying that it would be too much.
Mm.
So I can see that that you want to streamline it, and that's why there's a lead investigator.
Hmm.
Otherwise, everybody would be submitting their own
Yeah,
declarations.
I just found it funny that everything he did with the help of the FBI is basically what he was saying
I can't
on
even
this.
remember right now.
Yeah, it was
But,
crazy.
but I know that there were a lot of people that he got information from that he put in the affidavit,
Hmm.
and so I don't know.
Oh
It's
yeah,
all
true, true. Actually, he mentioned one that wasn't the FBI, and that was Maury, Detective Maury,
yes,
when it
yes,
came to the cast report. So that one I forgot.
yeah. I see you. I forget things, so I can't
Yeah,
really.
yeah,
But
I watched it so many
let me
times.
go to the bathroom real quick.
Yes, yes, yes. Go ahead.
Hold on, I'll be right.
Okay, okay. Sure, sure. All right. Sorry. Thank you for all the questions. I so appreciate you guys. And as I say, I'm so sorry I haven't been more active here with all you guys. It's been an interesting 2.5 hours almost, and I'm looking forward to, hearing more. I don't know about you, how you guys feel. I hope this is satisfactory and all your questions are answered, and maybe even questions you haven't thought about. And we're not stopping. We have two more questions here, I see. So we're not stopping until we get those as well. Just wanted to point that out. And again, thank you. And thank you for liking the video and subscribing to my little channel. And I'm very happy to be here and with you guys, and just be able to do this for me is a privilege, just so you know. It's not something I just take for granted, that I have an audience that actually listens and pays attention and appreciates what I do. So thank you. And know that I appreciate you as well a lot. So I'm going to bring up that next question, David Bird. I hope you're still here. I'm so sorry. Let me see. Hope you're here. And then we have another one from Tommy Jude. And thank you, Tommy. Thank you for being my moderator, my first moderator. I didn't think I needed one, and I think I saw something go down in chat earlier, so I apologize for that as well. I just didn't know what was going on and who that was. So thank you for taking care of that for me, Tommy. I appreciate you, my good friend. So we're going to keep these two questions, and I don't know if anything else will pop up, but then we'll stop it for this time, and then we'll revisit maybe perhaps after next hearing if something else of importance comes up. Not sure. I think the next hearing is going to be a few months from now. I don't have any information on anything until I guess they moved the hearing for that was supposed to take place in August. They moved, oh, sorry, in May. They moved that up till August or September for change of venue. So we won't see anything happening in a while. I don't know if there's no other really other that I'm missing. Any other
Hearing?
hearings coming up? I don't think so, right?
No, not that I know of, unless she
Yeah.
has more discovery hearings. But I'm waiting to see the orders from the judge
Mm.
about the motion to compel. Like,
I'm surprised they're not out yet. But I guess they give them a little time to produce, and then boom, one after another, they're going to pop up. Anyway, let's go to the next question. If DNA is tossed out, is buccal swab fruit of poisonous tree?
I think so, yes,
It's a
because
good question,
it
actually.
is because if the touch DNA is not deemed to be reliable, uh, and the question would be whether or not the procedures were followed, because there are certain procedures when you're dealing with touch DNA. And the FBI, I know that Ann Taylor laid it out in a motion. She actually attached those procedures and wanted evidence of like chain of custody, things like that. And I don't know if that's ever been produced because everything's under seal.
Mm-hmm.
But if they don't have the goods or the home, they didn't show their work, and or if it's deemed unreliable, then yeah, because part of the reason why they were able to get the buccal swab was because of the PCA, and because so if there is probable cause, then the buccal swab may not be a fruit of the poisonous tree. Okay, but if there is probable cause and they did the buccal swab, then the buccal swab stays. But based on what I'm seeing, if the DNA is tossed out because they didn't follow procedures, and if that's what the judge relied on for that heavy arrest in Pennsylvania, because in Pennsylvania, I understand you have to have additional probable cause. And so my thinking is that the DNA was the touch DNA. And so that's why the FBI took it over from Othram, or the state took it over, somebody took it over,
Mm-hmm.
because they wanted to rush it. I don't know that to be true, but that if that's the case, then the buccal swab is definitely fruit of the poisonous tree.
Mm-hmm. Very good question. I actually
That's
haven't
my.
even thought of that.
But
Um,
but if there is probable cause to begin with,
mm-hmm.
putting aside the touch DNA,
Mm-hmm.
the buccal swab is not necessarily a fruit of the poisonous tree because there was probable cause and they asked him for a buccal swab.
Mm-hmm.
But there wasn't. I just don't see that there was probable cause because
Mm-hmm.
everything's falling apart.
Correct.
Mhm.
All right, so we have question from Tommy again. The three DNAs that haven't been processed, why hasn't it been yet? Can't Anne force them through court? Good
Well,
question.
that is a very good question, and I remember this because Bill Thompson said they weren't qualified, or they didn't qualify, or something. They weren't able to test those DNAs, and the reason he gave was because they weren't qualified, or they weren't something. And nobody asked why. Why aren't they qualified to be put into, to be tested?
Mm-hmm.
Nobody asked that. And I kept thinking, why can't you like, what do you mean they weren't qualified? And that may have been answered somewhere, but I never found it answered. So I don't know why they weren't able to test the other three DNA, because from what it sounded like to me was that they weren't able to because they didn't qualify. And I don't know what that means. I still don't know what that means. And I would think that Anne could force them to do it, but if there wasn't enough of the DNA to do the testing, then maybe that's why they couldn't do it. But with Brian Kohlberger, I went through this, and I knew this maybe a long time ago when I went over it, that given the amount of cells of the touch DNA that they found, was there even enough to test it and put it through Othram Lab and go through all of that? Because each time you have to use a portion of the DNA. And so to me, it seemed like, how is the defense now going to do their own test if there's no DNA available because it was all tested? Like,
Mm-hmm.
do you know what I mean?
Yeah.
So it's this is baffling to me.
Mm-hmm.
And now my mind's rolling about what was it that they weren't qualified to be tested.
Yeah, and as you say, we haven't heard anything about that, but
I haven't.
I would think that Anne is still on top of that.
Oh, but remember they had the closed IgG hearing.
Yep,
That IgG discovery hearing was closed because she
correct.
wanted her investigators to look at it, and I don't know. Yeah,
Yeah,
but I don't know the answer. I'm with you, Tommy.
that's a good one, and I wish we knew more about it because honestly, the only answer we've seen is what Bill Thompson said.
They're
Yeah,
not
sorry.
really qualified.
Yeah, he wasn't qualified. Was neither was Koberger. So there you go. All right, I think uh, that's not a question. Okay, I think we got all the questions out of this. But I really want to thank you, Yoli, for coming on here and going through this with me. I appreciate you so much. You have no idea.
Yeah, and I'm
Um,
always happy to talk about Idaho 4 if I
we'll talk more. I mean,
Right.
there's things coming up, and I would love to see you. You know, you're always welcome. You know, I do open panels as well and things like that, and I always welcome you to join those. I like to do like evenings where people can just pop on and we'll talk
Mhm.
about everything. You
Yeah.
know, because my only thing is I can't sit here and talk to myself. I like to talk to people. I'm more like a people person. So I like to have people on my panel and I know some are very good at that. Like they can just talk for hours. And
Mhm.
I'm not like that. I like to get somebody to spin off on like, you know, back and forth kind of
Mhm.
situation. So that's why I'm more like I want to hear what you have to say, you know. So I'm more apt to have those open panel discussions where we can just pop ideas off each other. And
Yeah.
yeah, I never thought of that. That's a good question. And you know,
And so with me, with my work, I'm either all available, like
or
at
not.
time, or I'm gone. I'm missing. I'm I'm gone for a time,
Yeah.
and because of my work, I'm either very busy or I'm not.
Well,
And so
I hope we see more of you though, for at least for now. And I
it's
understand
something here.
I'm that too. I work as well. I have a full-time job, so you know, sometimes it's like rough, but I'm, you know,
Yeah.
I try to make it
So I
work.
disappear sometimes for weeks at a time because either because I do still do trials, but the courts can't get it together to do the trial. So
Yeah.
so I disappear for weeks at a time because of work, but then I have weeks at a time where I don't like I'm available and what do I do?
Hmm.
This is my hobby.
Yeah,
And so I would like to start a channel sometime, but I mean,
that would be fantastic.
but I wouldn't know. I
I
don't know the technology and shit.
I would watch it, and I like the way you do it now as well with Andrew and I'm sorry, I forget her name. I'm so sorry.
Uh, um, what Laney?
Laney, yes, yes. Andrew
Yeah.
and Laney. So I like that concept that they're doing it together. And then you come in there now as well. I mean, the more perspective and different lawyers and different experiences, at least for me, it's like it's so fantastic to watch. I love
Well,
it.
it's good because
Hmm.
I was actually happy to see another civil attorney talking about this case because I always
Hmm.
felt like, well, I'm not a criminal attorney. What do I have to say? But evidence is evidence, and it works. And actually, Andrew has done some criminal cases, but he's not a
Hmm.
criminal defense attorney, but
Hmm.
he's done some.
Well, you're a hop and a skip away from it too. So,
Well, yeah. I mean, to me, okay, when you look at it, it's about creating reasonable doubt. And I know that sounds horrible,
hmm,
but it's about making sure the cops do their job too.
correct.
Because if I had to defend a criminal and I had doubts about whether he was guilty or not, I would have to do my job and focus on making sure the cops followed the rules, did everything right. I
Hmm.
couldn't get too involved on whether he did it or not, or she did it or not. Because that's what you're not supposed to, you know. So going back to Ann Taylor when she said he's innocent, that's something.
Hmm. Exactly. It means a lot, I think, because you don't just say that. As I say, like you said, I think at trial, my opening statement, the defendant is not guilty, obviously.
Yeah.
But doing is so much, and they can't say it enough. It seems like, so they're trying to get their point across pretty heavy on that end. And
Yeah.
it's not just Ann Taylor, it's like Massive said it. Everybody says it on his team. So I find that very interesting.
Yeah.
So, all right, ladies and gentlemen, we're going to finish up the evening. Yoli, can you stay behind just a few
Yeah.
minutes?
Mhm.
And I would thank everybody for being here tonight and listening, and everybody on replay who will catch it on at another time. I appreciate you as well. And I can't thank you enough. That's all I can say. So, everybody have a good evening, and until we meet again, have a good one. See ya. Bye bye.
Okay.